Good morning and welcome to a meeting of the California Paraprofessional Program Working Group. I can begin by taking roll. Bashan.
Present.
Brennelson.
Here.
Falmouth.
Here.
Fleischman.
Here.
Hamilton. I don't see Stephen Hamilton, and I know Judge Harper isn't going to be able to join us today. Hartson.
Here.
Kirkmeyer.
Here.
McRae.
Here.
Olvera.
Here.
Justice Petru.
Here.
Robinson. Judge Rubin.
Here.
Shining.
Here.
Sarouche.
Here.
Spiro.
Here.
Torres Ambriz.
Present.
Judge Wiley.
Here.
And Judge Yu.
Here. Good morning and thank you.
Sure. Okay, we have a quorum.
If we could please, I see that we have 26 attendees, one of whom has their hand raised. If there are other attendees who would like to make comment, if you could please raise your hand and we'll give folks a minute to do that. And then Linda, I'd ask you to please call people with a 3-minute limit per person.
Okay. Okay, the first person is Olivier Taillou.
Good morning. Can you hear me?
Yes.
Yes.
Good morning. My name is Olivier Taillou. I am an attorney in Los Angeles. I practice primarily in the area of personal injury, although I have represented plaintiffs in all kinds of matters throughout my career. I speak to you today to make a fairly simple point, which is that you've heard a multitude of public comment from attorneys that represent consumers over the last year and a half. We represent the little guys. We represent the people. We represent migrant workers. We represent people who have been taken advantage of by their employers. We represent people who have been taken advantage of by corporations and insurance. We are the front lines of consumer protection in the state of California. We use the various tools that have been given to us by the legislature and the courts in order to enforce the rights of people who have been taken advantage of by those who have superior power, corporate entities, insurance companies, and other malfeasors. Yet our comments have been repeatedly ignored. We have been set aside as if what we have gone through, what we have dedicated our lives, our careers, do not matter. We know what goes on in the community. We know how for-profit corporations and entities take advantage of consumers in their most dire times of need. These are the people that you are also supposed to protect. Yet the State Bar has gone on a mission to open up the most vulnerable of our consumers to unabashed corporate practices by entities who only have one motive in mind: profit. Profit. And in doing so, you've not only set aside all of the public, almost universally, all of the public comments that have been against this program in favor of these corporate entities by doing one thing, which is to lower the bar. You are lowering the bar to access to legal services by allowing entities and people who are not attorneys, who do not have the education, the background, the experience to deal with the issues that we deal with every single day. And I am baffled as to why that is. When there are so many other alternatives.
30 seconds remaining.
When there are so many other alternatives that are available to the State Bar to improve the quality of legal representation in this community. I have no words that can explain or make me understand what is happening here. And I simply do not understand it. I want to thank you for your time.
Thank you. Linda, you may call the next person.
Steph Carroll.
Hi, can you hear me?
Yes.
Thank you. My name's Stephanie Carroll. I'm the Directing Attorney of the Consumer Rights and Economic Justice Project at Public Counsel. We remain wholly opposed to the creation of a new for-profit industry of licensees. The first words of the State Bar's mission say it is to protect the public. These proposals will fail to do that, and the pleas of consumer protection advocates from across the state have been routinely ignored by the working group. Subject matter experts have also been sidelined. In debt collection, where there is a thriving private bar that works on contingency, experts have repeatedly warned that clients of paraprofessionals in state court will waive their rights to go into federal court, where paraprofessionals can't practice. And yet paraprofessionals will be encouraged to litigate in state court so long as they don't go to trial. There is nothing in these proposals that will stop paraprofessionals from setting up in the hearts of our low-income communities. Nothing to make sure our communities know that there are free legal services who may provide attorneys or private attorneys who may take a case on contingency. And there is nothing to regulate the fees that may be charged. What's more, these proposals, coupled with the regulatory sandbox, conjure up a nightmarish scenario where the provision of legal services is taken over by faceless corporate behemoths that use paraprofessionals to provide services in a cookie cutter approach. That doesn't work to safeguard people's rights. That works to extract money from consumers for the least amount of work possible. With these proposals, you seek to institutionalize and legitimize the systemic racism embedded in our system of justice, ensuring the poorest in our communities continue to go unrepresented. They are no more able to afford $150 an hour than they are $300 an hour. And these proposals will end up providing a second-class service to many folks who could get much better outcomes from legal services organisations or an attorney who may offer contingency services so folks don't have to pay. So what's the alternative? How about work to better educate the public about their legal problems? Create non-profit navigators to help people understand their situation and get them hooked up with resources that already exist to help, and allow for attorney supervision. The failure of this group is that it has never considered such alternatives in
30 seconds remain.
way. Instead, it has focused solely on a for-profit model to the detriment of low-income consumers. I thank you for the opportunity to provide public comment.
Thank you. The next person is Lee Ferrin. You have 3 minutes.
Good morning. Thank you. My name is Lee Ferrin. I'm the Director of Litigation and Pro Bono at the Public Law Center. We, similar to Public Counsel, we remain concerned that the proposal will not do anything to actually close the justice gap, but rather will create a second tier of justice for those who cannot afford an attorney. As legal services attorneys, we're not going to lose business if this new licensee is created. Rather, we are likely to get more cases and possibly more difficult cases, as we often end up with the cases that go sideways. While I know that the working group has already voted on a resolution to not have any sort of fee caps or fee limitations, I would like to speak briefly as to why I believe that resolution should be reconsidered. Because of the way in which the working group and the subcommittees have split up the duties within each substantive area of law, there are going to be many cases for which a proposed licensee and an attorney will be needed. Unless the proposed licensee and the attorney are in the same office and or are working together collaboratively, it will be an extremely rare occurrence that an attorney will be willing to substitute into a case only for trial or only for an expert witness examination or cross-examination, for example. In our practice, clients regularly come to us after they have been representing themselves for some amount of time because they've gotten to a point where they cannot go any further. More often than not, unless we are able to reopen discovery or amend pleadings, it is very difficult for us to take on a case at that stage of the proceedings. The exact same thing will happen to people who utilize the services of the proposed licensee when that licensee has gone as far as they can go. The client will either be left with no assistance whatsoever and will likely be worse off than if they had not had the help of the proposed licensee in the first place, or they will be paying more for the attorney to redo some of the work that the licensee has already done. Fee limitations will not entirely solve this problem, but they are a mechanism that the working group can use to better protect consumers. We urge the working group to reconsider the resolution, that there will be no fee limitations at all. Thank you for your time.
And thank you. Let me just jump in for 1 second, just to note that, while we are going from person to person, we certainly are listening to everyone and making note of the comments. And speaking of comment, I just want to remind everyone that we are not in the position of deciding whether or not this program goes forward. That is not the role of the working group and not something for us to decide. It's up to the State Bar Board of Trustees what they wish to try to move forward. And we have been tasked with figuring out that if it goes forward, what should it look like? Similarly, our scope of directive, for lack of a better word, does not include looking into any kind of nonprofit navigation. That's simply outside our purview. So while folks are more than welcome to make any comments they wish to make, and we'll do our best to take them into consideration, I just wanted to pause for a moment for a reminder regarding what is actually within our scope to recommend and not. With that, Linda, if you could please go to the next person. And Linda, you are muted.
All right, Jacob Sabotin.
Good morning and thank you. My name is Jacob Sabotin. I'm an attorney with the Legal Aid Society of San Diego. My practice primarily consists of consumer protection and bankruptcy services. I just wanted to highlight a few issues I saw. If the goal is to increase legal services and decrease the justice gap, increasing paraprofessionals or licensing paraprofessionals is not really the solution. Licensing paraprofessionals will not increase legal services for socially disadvantaged and underserved communities. As discussed by the Paraprofessional Working Group, the steep licensing requirements means that these paraprofessionals will have to charge fees that very likely could be similar to what an attorney would already charge for these services. The issue here is not that there will not be a fee cap on these paraprofessional fees, it's that any amount of money charged is too much money when trying to increase services to socially disadvantaged communities. The LSC's own repeated studies have shown that for each of the almost 2 million people helped each year by their grantees, there's another person who was qualified for these services who was turned away due to lack of resources. Secondly, allowing paraprofessionals services with limited training will likely only increase the justice gap. The Consumer Debt and General Civil Subcommittee recommended increasing the training from 3 to 6 hours, as this area of law is complex and deals with several state and federal statutes. This recommendation was not heeded. This means there will be paraprofessionals with limited knowledge providing services related to complex statutes, many of which only have a 1-year statute of limitations. In the bankruptcy world, I'm already seeing issues involving non-attorney petition preparation services. These services fail to have the knowledge to properly advise clients and have led to disastrous situations by helping clients file bankruptcies that not only put their homes at risk, but also do not provide any substantial relief for their debts. Lastly, increasing access for socially disadvantaged communities requires a delivery model that builds relationships within that community. I've personally experienced providing services to these communities, and a relationship built on trust is one of the most effective delivery methods for delivery of these services. I provided free bankruptcy services to families who then brought in their cousins, their neighbors, their grandparents for assistance. Many of these people who would never even have sought out legal services without that kind of recommendation. Allowing for-profit professionals who have only tens of hours of training into these legal communities jeopardizes those relationships and will ultimately make it harder for us to deliver legal services. I thank you for your time.
Jeannie Harrison.
Hi, are you able to hear me?
Yes.
Okay, thank you so much. I'm Jeannie Harrison. I'm president of Consumer Attorneys Association of Los Angeles, and I practice plaintiffs' employment law in Los Angeles, representing, for example, Women Against Harvey Weinstein and the women of Riot Games and their equal pay class action. You should not pass the buck and say this is the Board of Trustees' decision. This group is voting today, and you should vote no. Some have dismissed what lawyers say about the problems and risks inherent with the paraprofessional program as protectionist. But this group and the program that's proposed is protectionist as well. It's protectionist about implementing the program regardless of the negative impact on consumers that you have been informed time and time again will occur. Allowing non-lawyers to own 49% of a law firm will result in the non-lawyers controlling decisions in cases, which is contrary to the fiduciary duties lawyers owe clients. Lawyers will unfairly be held accountable for the consequences of the profit-driven decision-making this group is authorizing. If you don't see how any of this will happen, or do see how that will happen and are voting yes on this anyway, then you're not putting consumers first. Allowing profits over people, business providers to practice law in California, which is the ultimate goal here, starts with the changes you're approving today. Paraprofessionals will staff Rocket Lawyer and provide subpar disaggregated legal services to those who can least afford to be taken advantage of. You heard from DAs and prosecutors around the state during your hearings. They all said they cannot adequately police the paralegals, notarios, and lawyers who are already licensed and in business. Over and over, they told you that the low-income communities are preyed upon by serial criminals and fraudsters, and that only the worst of the worst get prosecuted. This group is creating a whole new business model for taking advantage of the poor and underserved, and that will be this group's legacy. Every one of those victimized in the future will be a consequence of what this group is doing. California provides
30 seconds remain.
California prides itself on being a leader in consumer protection, but what this group is doing is lowering the bar on that protection. Along with the many legal aid organizations that are universally against this program, we urge you not to unleash even more new licensees to disproportionately prey upon the low-income and underserved communities. You can and should vote no today. Thank you.
Jennifer Ostertag.
Good morning, Jennifer Ostertag. Can you hear me?
Yes.
Good morning. I'm an attorney in Los Angeles, and I've been representing plaintiffs for about 22 years. And I'm also a member of CALA and the chair of the Beverly Hills Employment Law Section. I am extremely concerned that the State Bar and this committee has refused to listen to all the comments we've been making for over a year now about the danger of the program that is being proposed. We represent consumers. Like Mr. Talia said, we are the front line. We have been fighting for years for people who don't have a voice. The committee has chosen to resolve the consumer lack of access to justice by kicking the door for corporations to create a profit model that never works in favor of the consumer. That's works for corporations and for investors, but the consumer is always left behind. Instead of advancing its mission for the advancement of the ethical and competent practice of law, this committee is lowering the bar by proposing modification to the rules of professional conduct. Instead of lowering and modifying those rules must be stricter for non-lawyers than paraprofessional or corporations. In addition, the paraprofessional proposal does not adequately address the need for accountability measures, a framework to determine who will be responsible when a consumer is ultimately harmed by a paraprofessional inadequate representation. It seems that the State Bar is wasting a lot of money to create a program that has already proven to fail in Washington. California has many lawyers. We are not like Utah. We are not like Arizona. We fight for our consumer, and we have made progress. We have very advanced law in the protection of consumer, thanks to the work of all of us who fight on a daily basis. How is this committee going to ultimately hand off to ensure that a consumer who is harmed by a professional representation is made whole? Is a bond going to be required? What are the protection in place for the consumer that you're going to put forward? Attorney face the threat
30 seconds remain.
When attorneys are facing the threat of strict discipline and possibility losing their license or being sued for malpractice, what will a paraprofessional fear? I mean, those are very fundamental question that this program needs to answer. You are dangerously assuming that the cheaper way of providing access to justice.
The 3 minutes are up. Thank you. Allison Snow.
Hi, my name is Allison Snow, and thank you for this opportunity to speak to the bar and be able to really convey deep concerns. As a consumer protection attorney, I spend all day with clients helping them evaluate what they can afford and what they can't afford. And basically, this is one of those situations. The bar can't afford this. Financially speaking, it can't afford it. Washington was an incredible failure, costing literally millions of dollars with no way to pay those bills. Similarly here, there has not been enough analysis. Lawyers are notorious for not being accountants, and that's exactly the case here. There's no way to account for how this program is supposed to be self-sustaining. Not to mention the impact that it's going to have on our law enforcement agencies who are tasked with the responsibility of trying to go after fraudsters and other issues that are rampant in the already existing programs that have already been pointed out, including the notarios and the petition preparers in the bankruptcy forum. Washington Supreme Court, on a 7-2 vote, decided to shutter its program due to its inability to sustain itself financially. We face the same problems here. There's been no discussion to address how we're going to be different than the Washington model. Its limited licensed legal technicians program there in Washington was an unmitigated failure. And now they're left with paraprofessionals that they continue to have to support and provide resources to, with no way of really financially understanding how that's going to happen. The reason cited for shuttering it was overall costs, a small number of interested persons, and it was not an effective way to meet these needs. Similarly here, this is not an effective way to meet the needs and that close the access to justice. In repeated reviews and research opportunities, it's shown that civil legal services, which are free, are the most effective ways to reach and bridge the justice gap that we have right now.
30 seconds remain.
This current model is not an effective way to meet the needs, and the state bar is going to be saddled with a debt it can't afford to cover. And so with that, I appreciate the opportunity, but really encourage the bar to think and learn the lessons of Washington and decide now that even though we've invested thousands of hours in developing this project, that it's time to cut bait and move forward with programs that work. Thank you.
Angela Grijalva.
Good morning. Can you hear me?
Yes.
Okay, wonderful. So thank you for this opportunity to speak. I'm hoping to break up the overwhelmingly funded attorneys and not-for-profits who are attempting to shape the narrative of access to justice. First of all, y'all do not represent the consumer. You represent your main, to remain funded and keep your elitist access to legal services intact. So please stop touting and using the poor underrepresented in vain. I was a homeless single mother escaping domestic violence. I survived, overcame, and still challenged to overcome the systemic inequities. LDAs have been providing non-attorney professional services for over 20 years in California without issue, because none of you have brought or claimed that as an issue. Thank you so much. I don't need that. No, thank you. No. The peanut packets. Sorry, guys, my Starbucks order. Anyway, so please stop. And before, I recommend that this committee, before they allow any of these speakers to speak, please identify your sources of income, how much you make every month, okay? And you're not the front line, okay? I'm the front line as a legal document assistant working with these individuals who can't afford to hire you. They can't get access from the self-help or not services here at the courthouse, and they can't get access at the not-for-profits because they don't qualify, right? So if we're going to talk about the issue, we have to understand it in the tiers that it exists. There's the people who can afford legal services and your $5,000 retainer. There's the people who can qualify for your not-for-profit services and the people in between. That's right. This is not going to necessarily create this free legal services. What it's going to create is an affordable legal services for those people in the middle who don't have access to it. So I'll end there. I appreciate y'all's time. My only other concern that I think about this committee, and I'll bring up and I'll keep reminding us all, is that in the issue of the Washington model, and oh, by the way, for y'all saying there's no other successful models, there's successful models throughout the United States and other states. Okay, do your work, right? Don't just come and complain, come with solutions. Anyway, so my concern is that the paraprofessional would be licensed and supervised under the state bar, which is a conflict, right? We should take this outside of the state bar, and instead of creating a whole new profession, let's evolve the LDA. Let's expand the services that we offer. We're doing it successfully right now. Increase our educational requirements, increase our scope of services. Let us select documents. The Judicial Council already selects the documents. They're mandatory. Let us, those who have been successfully doing it for 20 plus years, continue and expand. Thank you. Amen.
Amy Kirby.
Hi, good afternoon. Can you hear me?
Yes.
Oh, thank you so much. I appreciate the time to be able to speak. I've spoke at one other hearing. I have a unique perspective to bring to this. I am a plaintiff's attorney. I represent consumers from everything from children being raped at the YMCA to children being raped at school districts. I also volunteer within the Los Angeles Superior Court system in both civil and criminal. I've heard people come to me with basic stories asking for help and being able to use our legal system. I'm also licensed in Arizona, Texas, California, Georgia, and Nevada. So I bring that experience to my comments. What I'd like to say to you guys is that we get cases as trial attorneys from other law firms. Sometimes these cases are so badly worked up, we can't help these people. And that's what's going to happen with these individuals. If we give the license to these individuals, they're able to go part way, but not all the way. And when we see a file like that, we will not pick up these cases. These will be people that are worse off than if they sought legal aid through some of the organizations that have spoke to you. You guys have an opportunity to shut this down, to say, we're not willing to do this after we've looked at everything, because this is going to harm people. This is going to put people that are the most vulnerable in corporate hands. And we know what happens there. I would urge you to take consideration of some of these comments. Don't giggle or laugh or shake your head, but think about what you can do for the little guy. Think about what you could do after evaluating all this evidence, and vote no.
Michael Barth. I guess he's not able to speak. I got a message from Zoom that he's using an older version of Zoom and he can't speak.
Can you hear me now?
Oh, there you are. Yes.
Sorry about that. I'll start from the top then. My name is Michael Barth, staff attorney with Public Counsel. The Access to Justice study showed that one of the main contributors to the justice gap is that people don't necessarily know when and how a lawyer can help them. We believe that the well-documented issues with notarios should provide a cautionary tale to the state bar. As an example, Public Counsel has been made aware of at least 9 different individuals who were victims of a notario service that purported to assist homeowners with issues involving the Property Assessed Clean Energy Program, otherwise known as PACE. It's basically a financing scheme involving home improvement loans. All these homeowners sought legal representation after a home improvement contractor enrolled them in PACE financing, but then failed to complete the promised work. This non-attorney notario promised to file a lawsuit on the homeowner's behalf to address their PACE issue, and then continue to pressure the homeowners to pay fees upfront, ranging from $2,000 to $3,500 a piece, by visiting their homes or calling and texting them repeatedly. After extracting the fees, the notario eventually cut off communication with this group completely without providing any legal services at all. This tragic story should create pause when considering adding a new class of licensees. This new class will only further confuse low-income communities, particularly in combination with a lack of fee structure reporting and lacking a mandate to disclose legal aid contact information. Further, it's already impossible to get adequate oversight and enforcement in place, even with the egregious misconduct and crimes that occur with purported or actual legal practitioners under the current system. A campaign to better educate the public would be 1,000 times more impactful than creating a new set of licensees that will only further confuse the public and spread oversight resources more and more thinly. Thank you for your time.
Thank you. I don't see any more hands raised. Oh, just had another one come on, Spencer Palkey.
Hi, can you hear me?
Yes.
My name is Spencer Palkey. I'm a consumer protection attorney in San Francisco. I've been practicing for about a decade and a half. Now, ultimately, the committee has chosen to solve a problem, consumers' lack of access to justice, by doing something that I think history tells us is frightening and dangerous and not a good approach. That's inviting profit-driven corporations to create for-profit businesses that trade quality legal services for a cheaper, flimsier, and frankly counterproductive substitute. The dangerous assumption here is that cheaper is always better, and that's not going to be the case, especially when it comes to legal representation and in the face of what your mandate is to protect the public. The question that comes to me is what corporate conduct in the history of corporations and market-based economy has given us any reason to trust that for-profit corporations sworn to protect their shareholders' interests first would do anything to address the justice gap? If subprime mortgages, predatory lending, and anti-consumer monopolistic practices, which are abundant in our history, are any indication, it's obvious that increased corporate involvement cannot and will not be a good thing for consumers. Let's operate based on what history has told us. This is not a good idea. Thank you.
Susan Swan.
Hi, my name is Susan Swan. I represent employees in San Diego, and please vote no. There's no accountability in this. Bringing in a for-profit model is not the answer. The alternative solutions have not been explored. There's no data to prove that this will work, and what pro se litigants really need is free and better resources. Ultimately, this is going to harm consumers, and as Ms. Harrison said, don't pass the buck by saying, oh, we don't make the decision. You are a crucial part of this process, and you should vote no. Thank you.
All right, thank you, Ms. Swan. We are going to stop. I don't see any further hands. I'm going to come to.
My hand is raised.
No, Claudia, I'm well aware of that. I'm looking at the attendees as opposed to the working group members. And I see that Peter Corrales just raised his hand. We are going to pause on public comment at this point as we have gone for over half an hour. And we will resume public comment after the lunch break if we have people at that point. Claudia, absolutely, we want to hear from you. Before we do that, I would like for Leah to remind us, because there have been some comments that to me make it sound like we are above the state bar and have some kind of authority to tell the state bar whether this should be this program at all or not. So Leah, I think, is uniquely positioned to remind us of what the mission is here, who has the authority to do what. And then Claudia, we would love to hear from you.
Okay, great. So just as a reminder, the working group was established pursuant to the board's direction, and the Board of Trustees did specify a charge for the working group, which was to develop the parameters for a paraprofessional program to include a paradigm for licensing, regulation, and discipline of a new class of state bar licensees. Importantly, the charge did not include addressing the question of whether or not a paraprofessional program should be established. And I think, Justice Petrie, that's one of the points that you wanted me to make. The working group is in fact tasked with doing precisely what it has done. I also want to point out and clarify the distinction between this effort and the Closing the Justice Gap working group. And I acknowledge that it can be confusing to have several related initiatives underway at the same time. at the state bar. But the Closing the Justice Gap Working Group is in fact on a much more extended time frame, with its recommendations coming to the board in a little over a year. And there, that group is considering this concept of a regulatory sandbox. And we've heard public comment to that effect. This morning. The sandbox is not related to the work of this working group. The sandbox is a concept in the regulatory world where new entities could come in and test out different models for the provision of legal services, but not the licensed paraprofessional that you all have been working to develop. So I wanted to clarify both of those things, and then also to remind the group that the final report from your working group will come forward to the board at its September meeting. The board will be asked to put out the entire report and recommendations for public comment for a 60-day period. It will do that. This working group may be asked to come together one more time to review public comment. That would happen in December, and to decide if any changes are warranted to your recommendations based on that public comment. And then the board will make a final decision on the recommendations of this group at its January meeting, January 2022. At that time, the board will submit a proposal for program implementation to the Supreme Court. And once the Supreme Court gives an initial authorization to proceed, the State Bar Board would then approach the legislature. And that is anticipated to occur in the spring of 2022. And that will begin a process that will involve a significant amount, I am sure, of public input, culminating in a decision that would be reflected in the State Bar's 2023 fee bill. So we have quite a number of steps that need to occur before this program could in fact be implemented, and there will be many additional opportunities for public comment. So hopefully, Justice Petrie, that's what you had in mind with my clarification. And with that.
Yes, it is. Thank you. Claudia.
Thank you. So I am a member of the Paraprofessional Working Group, but to clarify, I have no skin in this game. I'm just a consumer. I'm not a lawyer. I'm not a legal educated person. I'm an MFA. I'm an artist. And I joined this committee because I wanted to educate myself as to what is it that the state board does? What is it that they are trying to do? How are they trying to help with the justice gap? And I'm speaking in defense of the consumers. I hear a lot of the folks advocating for this entire work to be dismantled and forgotten. I strongly oppose that. I have witnessed at my own expense, because I don't get paid to be here and I lose work time to be here. I don't have paid time off. So every single time that I'm sitting here, it costs me money and I can barely afford that. So when there's some accusations that there's some sort of gain from us, there really isn't any gain financial. There's nothing that I'm getting out of this money-wise. So I'm just speaking here on behalf of consumers, all the folks that I interact with who are not involved in this seeking profit. We just want help. We want support. We want to have more avenues, more paths to follow. Someone said, tell us how much money you make. Well, I'll tell you, I have been underemployed and unemployed since early 2019. And it is not easy, right? This is very difficult to be a part of. It's difficult to hear all of you fighting with each other. It's difficult to hear the implied racialized violence when some of you use words like notarios, which I have spoken against before. And I have said, when you use a word like that, it is implied racialized violence. It is related to the other word, sicario, which is a violent mercenary who murders on behalf of drug lords. So to make that kind of a psychological association with a notary public, that sure, some of them may be not the best folks, but you can say that about anybody, lawyers included, anyone. none of us are perfect. We are all people. Some of us people are profit-minded, right? I'm not yet. I'm working on it. I'm not the best. But really, I'm just speaking here for the work that I have witnessed from this working group. I was a member of the Licensing Committee, so I know that many, many hours beyond mine were invested in making sure that the education was clearly defined. We definitely compared all of the other existing programs to make sure that we had the best combination of them all so that it was still accessible. Because it's not just about education, it's not just about regulation, it's also an opportunity for some other people to develop their own career paths. So it's an educational opportunity for some people, right? And ultimately, as a consumer, I want more options. So I know that everything that has been developed is not perfect. I know that we can actually make this happen. We can only recommend that it does happen, and we can provide all of the work that we have put together as a group of people. But really, I am just advocating for consumers with nothing to gain but support. Thank you.
Thank you very much, Claudia. And you know, a lot of people who are on this working group, myself included, are very used to speaking up and very comfortable doing so. And, you know, like to, you know, I won't say like to hear ourselves talk, but are very used to hearing ourselves talk. And I appreciate that may not be quite as easy for some other folks who are on the working group. I don't know whether it is for you or not, but I would just encourage you and others to just speak up as you just did. I think it's very valuable to hear a diversity of opinions, not to minimize any, you know, comments from the public, but, you know, there are a lot of different voices, whether they're attorneys or not, or legal trained or not, or, you know, people of wealth or not, that need to be heard. And so I appreciate your doing so. Thank you. Ira, I believe you just raised your hand.
Yeah, I did. I'd like it to be made 100% clear to everybody, the public listening in particular, but me too, exactly where the decision lies about whether corporations and big businesses or other business are going to be able to own firms that employ paraprofessionals that eventually probably will be licensed by the state bar. I think it's the recommendation about ownership of those businesses, those corporations that employ paraprofessionals. I think the recommendation is going to be with that sandbox group. But I think the public needs to know for sure. I learned recently that it's not with us. I wanted to propose something to limit the size of any such businesses to 5 or 6 paraprofessionals, so big business couldn't be largely profiteering off this. But would somebody please make it clear to the public where that decision will lie? I guess maybe at a number of levels.
Yeah, the decision will not lie with the Closing the Justice Gap Working Group, but the Closing the Justice Gap Working Group will develop a recommendation on that issue with respect to the sandbox, the regulatory sandbox. That would obviously then have to go through numerous steps in order to actually be effectuated, just like the recommendations of this group will. But you're correct, Ira, it is not an issue under the purview of this working group.
All right, thank you. Then Fariba, have your hand up next.
Thank you very much. I want to thank all those who made public comments. I heard some really great ideas, such as a nonprofit navigator. I just want to say, you know, nothing's stopping nonprofits from getting together and creating something like that. And I'm just wondering why one hasn't been created. Here at the Self-Help Center, having done this work for 23 years now, we see people who aren't able to get help from legal services agencies, from pro bono agencies. Yes, high impact cases, what they call high impact litigation. Yeah, they may get help. Domestic violence, great, fantastic. They may get help. Some child welfare issues, yes, they get help. But just a run of the mill, and we do a lot of family law here, divorces, request for custody visitation, child support, they're not able to get any free help. And if people have a little bit of money and they don't want to wait for self-help, because self-help is not for everybody. We help people help themselves. If they do not have time to wait, because we certainly don't have staff to meet all the demand. And if people are not functional enough to help themselves with court forms, they're in that middle ground. I think Ms. Grahava put it perfectly. And that's where these paraprofessionals can help. Whether this work group succeeds and there's a vote to launch a program or not, there is business for legal document preparers, independent paralegals, form preparers, whatever they call themselves, okay? They are bad actors out there are running rampant. At least this program offers a way to, a practical way to regulate these folks, to license them, to educate them, to provide training, to provide oversight. Nothing exists out there right now. So to me, this program, it actually provides way more consumer protection that exists out there right now. And again, I want those the people who commented with these great ideas to provide more legal services, pro bono, low bono services out there, to get together and still do that, because there is demand for your services as well. Thank you.
Carolyn.
Thank you. Okay, so I just wanted to say two things. I also wanted to say thank you to Claudia. Her perspective is really important, and it sounds like it was very heartfelt. And I just want to say thank you, because I know this is tough. And just thank you. I also just want to say I have comments and thoughts on the for-profit, which is embedded in 5.4E3 that was discussed, and there might be some other sub parts to that. I don't want to do it now, but there's been some discussion of for-profit and the impact we are going to have. And so I know and understand what Leah is saying and other folks about the actual technical aspects of what we're going to do, but I would respectfully disagree. And I'll point out later if I have, hopefully I'll have a chance, as to what this group means in terms of what our recommendations are really going to do in history, in comparison with the history of what groups like this have done across the country. So I hope I get a chance to do that later. I just want to throw that in there really quick.
All right, then it looks like we don't have hands up. Why don't we roll into, and Leah and Linda, I'll let you take lead on talking about where we are with naming.
Right. I think as part of the chair's remarks time, we were going to give you all an update on the licensing name. Linda, are you prepared?
Yes.
Okay, great. Thank you.
So, so just to review, we reported, I think in June, on the results of 2 surveys that were conducted among the members of the working group. And initially some of the staff that's been working with this program on potential licensee names. And the potential names that were circulated for this survey were based on discussions that both Justice Petru and Leah had with a branding professional who works on developing names. So this was what was in the initial survey. And then we did a follow-up survey. The initial names, Leah and Justice Petru went back to the branding expert, and based on both the names that rose to the top, as well as a lot of the public comments, we circulated another survey that had that narrowed down the names for selection. And these were the ones that came from the follow-up survey. And you can see I have an asterisk. And what you'll see as I go through the next few slides, this name, limited license legal practitioner, seemed to rise to the top in a lot of the feedback. And you can see these were the top 3 names. And I think Justice Petru at the meeting in June discussed this, that these were the names that we were going to potentially bring forward to the board. But at that meeting, this was some of the suggestions that we got, that when developing this final selection for names to promote to the board for consideration, these were the issues that were raised and the consideration. So how would the name be translated into Spanish and other languages? Avoiding acronyms that might lead to confusion among consumers like LLP and LLC. There was a lot of input on avoiding terms like certified and licensed. And it was interesting because some people suggested that we should include the name licensed, but there were concerns that were raised about that how licensed in Spanish, when it's translated in Spanish literally, that term is often used to mean attorney in Spanish. And you can see the names that were suggested at that June 25th meeting for inclusion. So what we did is we sent the potential names, and I think we sent about 8 names to these. We have 2 contracts with 2 professional translation firms, one that the State Bar uses for both written translations as well as for interpretation. We have immediate interpretive services available for people who call the State Bar who need assistance. And these were the recommendations that came back based on the Spanish translations that were provided, as well as concerns that were raised about the potential confusion. And the feedback I got I had an extended discussion with someone at one of the translation firms about the term licenciado. And even though that is used colloquially for attorney in the Spanish-speaking community here, what it really means, it's referring to the actual licensure. And so it's kind of a shorthand term, but it would not necessarily be used to mean lawyer. And the strong recommendation that the translation firms provided was that we can avoid potential confusion and everybody going out and independently translating by when the program is promoted, all the literature and all the promotional information includes the terms that have been identified with their translations into those languages. We went back and brought these potential names that were being considered to the licensing subcommittee.
I think Linda, the regulation subcommittee.
I'm sorry, I'm sorry that there's an error on here. I guess because I'm using the term licensee. So
And
this
Linda,
should say
we have-
regulation.
Linda?
Yeah,
Judge Rubin has his hand up.
sure. Judge Rubin?
I don't know if now is the time. I was just curious if we had fluent Spanish speakers in our group.
I think we're going to address, I think, Linda, you have a slide addressing translation, correct?
Yes. I was going to ask if they agreed with what the outside firm said.
Yes.
I agree.
Yes, so yeah, we sent the names to Elizabeth. We didn't send it to other Spanish speakers in the group, but we sent the translations and that feedback to Elizabeth Olvera, who provided her feedback, which is part of what we brought to the regulation subcommittee. And the recommendations based on the conversation with the regulation subcommittee, these are the names that were suggested. And you can see again, the limited license legal practitioner was among them. Ira, you had a
well, I've been fluent enough in my career to represent people who spoke Spanish and not English. And I was referred to as licenciado over and over, like hundreds of times. And also, even though the translation service tells us, what we can see here, and as far as I know, that, I mean, they know better than I do. That's a correct translation. Still, I can see misuse of the term licensed by people who want to come across as lawyers, calling themselves licenciado. And what is that word? It's the past tense of license as a verb. So I think it's, regardless of the correct translation, according to the translation company, it's going to lend itself to misuse.
And just to address that, as you can see, this limited license legal practitioner doesn't have that past tense of licensed. So that might help to alleviate that concern. Julia? Oh,
I had done mute. The other thing is it's not either just past tense. It is like saying attorney, doctor. So sometimes there are other professions that are called licenciado that have graduated and received a title as a professional. But I think that licenciado is most commonly used only for attorneys. And instead of just calling you an abogado or something like that, they call you licenciado because that means you're licensed to practice law. So I think that it is colloquial enough, common enough that we should steer away from the word licensed in the title. That's my 2 cents.
Claudia?
Thank you. I do speak Spanish. I'm actually a native born Spanish speaker. I'm fluent. And I think you made the correct choice in the phrasing of the title. In the way that it is written, in no way could that be synonymous to licenciado. And as it was said earlier, correct, licenciado could also be applied to other professions because essentially once you get a bachelor's or master's, they just call you licenciado. It means you got your degree. But yes, most often more common with the legal profession. So in the way that you have it written here, it's very clear that that's not to be confused with a licenciado. This is a limited license. You're specifically calling them asesores, so that's a counselor. It's someone that can assess. It's not an actual lawyer. So this is very clear that these are not lawyers.
So Claudia, can I interrupt real quick? Which is the one that you're saying would cause the least confusion in your opinion?
I think asesor legal limitado is quite useful because it is clear that it is someone that can counsel you about the law in a limited way. Asesor legal con licencia, that implies that you have to have a license to even give legal advice. Practicante legal con licencia limitada, that is someone that is working within law with a limited license. That one I think is a little bit more confusing. So of the three, I would go with either of asesor legal limitado or asesor legal con licencia, depending on how you want to, put the emphasis on.
Thank you.
Of course, thank you.
Amos?
Thank you. I just wanted to make it clear, because I think this might have been confusing, that at least the Regulations Subcommittee, I believe, and certainly myself on the Regulations Subcommittee had a very strong objection to the middle one, licensed legal advisor, because that doesn't include limited, and it was translated by the translation services as abogado. And as people have mentioned already, the licensed also was cause for confusion. So at least personally, my view was expressed, and I believe the Regulation Subcommittee had significant concerns about not including the word limited and including the word licensed. And so I think we rejected, or I rejected the middle one.
Carolyn?
Okay, thank you.
Sorry, Carolyn, I just wanted to interject a comment. I appreciate that there was some feedback given. I certainly appreciate Claudia's comments. I do think though, we are using professional translators, and I think we do need to rely on them, just like we would in court. Say, we have to rely on what the professional translators are telling us. So I just wanted to do a quick jump in. Carolyn?
Okay. Can I just respond to that real quick? Because I think it's the professional translators that interpreted that middle one as abogado.
Right. Okay,
That
Carolyn?
was actually, that was an initial translation where they didn't really understand what we were intending with this. And so as I said in my memo to the Regulation Subcommittee, I went back to that same translation agency and spoke with someone more in depth who provided revised translations that did not include the term avocado. And this is where there was this strong urging that we make sure that when we publicize the program, we push these terms in the native language, in the appropriate languages out there so that people aren't going and doing their own translations.
Carolyn?
Okay, I want to go back a step because we started this by being given a, we were told as a working group that the name was going to change. And I don't remember ever passing a resolution that said we all didn't like the name paraprofessional. I voted in the initial survey where we were given 40 names, which did not include paraprofessional, to use paraprofessional. We've been using that name for almost at least 2 years, and that's a name that's commonly understood across the country. So I'd just like to hear from, Linda, Leah, how we came to this conclusion that the name had to change. It's in our working group title, and I think it might cause confusion just in general about what we've done for 2 years. So why didn't we use, other than the fact that nobody voted for it, even though it wasn't on the list, when did we decide and why that paraprofessional wasn't going to do it?
I think paraprofessional is a very generic term.
Yeah, it was really like a placeholder term. And I think because it never actually generated any votes, it didn't go forward.
Yeah, and I don't, Leah, if you want to make further comment, that's fine, but I don't want to go over because we did talk about this early on and at various meetings. The fact that it was generic, the fact that we were going to be looking into it. So Leah, unless you have other comment that you'd like to make about that, or Linda, I think we need to move forward.
Judge Yu does have her hand up though.
Oh, I'm sorry. I was going to tell Carolyn, it's sort of like Pfizer going to a different name, Comity. I sort of agree with you that we've all thought of this as paraprofessional working group. And I think I did vote for that in the very beginning, but it didn't make the cut. So I just wanted to say I agreed with Carolyn in that regard.
So moving on, as Justice Petru discussed at the June meeting, this group is not going to vote and decide on a name that is going to be used for the licensee. What the recommendations that go to the board are going to include some suggested names, and these are the ones that, based on all of the feedback, that we're at this point planning to include these recommended names for the board to decide. We will provide all of the background information about how we've come to these names. And further, when we provide the name recommendations to the board, it will include languages other than Spanish. So we focused on the Spanish translation because there is, that there were issues that were specifically brought up, but due to time considerations, we didn't do the in-depth requests for the translations into other languages the way we did with Spanish. These are the main languages that have been identified as prevalent in California. And so these are the translations that will be provided when the recommendation goes to the board.
Julia?
So other than this conversation we're having right now, we are not going to take any kind of a vote to say out of the final remaining choices, at least this was the feeling of the group, so that we could, after consideration, especially hearing from Claudia and other people, can we at least make some sort of recommendation of sorts?
The concern with that is that I don't think we'll get to any particular, like 3 names that the whole group will vote to promote. There was
Julia, are you talking? Yeah, Julia, are you talking about trying to take a vote on the 3 names that we propose moving forward? Because I agree with Linda, we're not going to go back to square one. She went through how we got to this point, and I'm really don't think it makes any sense to go backwards and redo conversations we've already had. So I would like to understand if you're asking for a vote of between these three names that are currently on the screen or for something else?
I would like to take a vote on the three names currently on the screen.
And I don't have a problem with doing a straw poll. I don't think we're going to get a majority. If we do, we do. That can be included in the report to the bar. But again, I've given all of the input that we've had in various full group and subcommittee meetings, and given the very real pluses and minuses of any name, which exists with naming anything, I think we should continue with our plan of putting forward three names with the pluses and minuses and concerns that have been raised and positives that have been raised. But if folks want to take a straw poll for that to be included in the final, in the recommendations and thoughts that are shared with the board, I don't have an issue with that. Claudia?
Can I just
thank you.
quickly-
Just a
Oh, sorry, Claudia. Leah?
Yeah, Brady, maybe
Yeah.
we'll hear from some additional members. Could you weigh in, because we do not obviously have a vote on the agenda.
Right. I was just checking the agenda to make sure I hadn't missed anything, and it doesn't look like I have. This was sort of a staff update, and there was no action contemplated. So
We can't do it.
Under Bagley-Keene,
Okay.
nobody was given notice. We'd be voting on this.
Thank you. Claudia?
Oh, thank you. Just a quick misspelling on the middle one. Instead of practicando, just change it back to practicante like you have on
Yeah.
the one on the left. It's a real simple one.
Thank you.
You're welcome.
Kimberly?
And I know it's not going to vote or anything, but I did have a question since Claudia is on the line. On the one on the right, the limited legal advisor, one question I had, and you brought it up, is that it looks like this individual is only able to give advice. That was one of my concerns. And so just to put it on the record, is that kind of the thought? If an individual saw this and they saw the word advisor, they wouldn't think that this individual would actually be able to represent them. In your opinion, based on the translation, is that the thought that you would have?
I would not expect an assessor to be able to represent me in court, no. I would expect for them to explain to me what are some options that I may have, that they may have a further legal background than I do, and that they are authorized to give it to me.
So that is my one concern that I have, that just to put it on the record.
That's fine. And that can be, we can talk about how we move things forward. So Kimberly, if you could take your hand down unless you have other comment. Claudia, do you have other comment? Okay, thank you. I don't see any additional hands. I do see a hand up in the attendees. I will go ahead and take that comment if it relates to the naming. So Linda, if you could please ask Philemon Sampson.
Hello, Philemon. Did you want to make comments specifically addressing the licensee name? Philemon? We're not hearing anything.
I don't believe he's his hand's raised, but I don't believe that he's there. Okay.
Hello?
Oh, hello. Did you have comments regarding the naming issue?
Yes, I just wanted to say that the comments of both Ira, Catherine? Ira, Julia, and in particular Claudia, regarding including the word licenciado, I think were very good. So that it would be extremely confusing and leads to the potential for both confusion and possible misrepresentation if you include that word or a version of licenciado in the ultimate title.
Thank you. All right, Linda, Leah, do we have anything further on this?
No. No, we don't.
Leah, anything?
No, I just want to say I appreciate all of the attention that members of the working group have paid to this issue. And I really do think it set a model for the State Bar going forward, with respect certainly to sending names out to professional translators, and to be very intentional about understanding the impact of the decisions around naming on our very diverse communities in California. So I appreciate it, and I think you'll see more of this out of the State Bar going forward.
All right, thank you. Linda, could we please take care of the minutes?
Yes, but before we do, can I just take a moment in your chair's report time to update about the status of the report that's being drafted?
Yes, well, if you don't mind, because I'm deeply concerned at this point that I will simply forget about getting the minutes taken care of. So if we could just take care of those and then you can roll into your comments, that'd be great.
Sure, let me just bring up my voting slip for that. Okay. Okay. So do we have a motion?
I move.
Who was that?
Tariba.
Okay.
I'll second. It's Julia.
Okay. Okay. If there's no discussion, I'll go ahead and take a vote. Bashan?
Yes.
Brynelson?
Yes.
Helmuth?
Yes.
Fleischman?
Abstain, I haven't read them.
Hamilton?
Yes.
Hartston?
Yes.
Kirkmeyer?
Yes.
McRae?
Yes.
Olvera?
Yes.
Robinson? Robinson? Okay. Oh, I think that she said she needed to
Yeah,
step
reminder
away.
she had to step away for about a half hour this time.
Right. Shining?
Yes.
Sarouche?
Yes.
Spyro?
Yes.
Torres Ambris?
Yes.
Judge Wiley?
Yes.
Judge Yu?
Abstain, I missed that meeting.
Okay.
Okay,
I didn't hear my name.
Who was that?
Judge Rubin. Didn't
Oh,
hear
I'm
my-
sorry, Judge Rubin, you're right, I skipped you. I continually do that.
That's okay.
Your vote?
Yes, thank you.
Thank you, I apologize.
Judge Rubin, I hope you're not getting a complex.
No, I'm gonna go cry quietly to myself. I'll be right back.
Okay. Stephen Fleischman, can you tell me what your comments are about so I can understand whether it makes sense to take them now or after Linda tells us what she'd like to tell us?
Yeah, I had emailed you, Justice Petru, that I wanted to move for reconsideration on the non-lawyer ownership issue.
Right, and yeah. Let's hear Linda's commentary first regarding status, and then let's do that.
Thank you.
Sure. So as you all are aware, I hope I've been sending out sections of the report that will be presented to the report for review. I've been sending them out as they're completed to allow you to provide some input before they're posted to the agenda for the September 10th meeting. Our goal is to get them posted on Friday so that the full report will be posted a week in advance of the September 10th meeting to allow everyone the opportunity to review and provide additional comments. At this point, I don't anticipate having any additional sections to send out for advanced review. I've sent out all the most controversial ones so far. I sent out the preliminary outline of the report, the section on fee caps and in-court representation on August 20th. I thought I sent out the rules on August 25th, and I apologize, there was an administrative error. They didn't actually go out until yesterday. And yesterday, I also sent out the sections on the practice areas and regulation. And thank you to those of you who have already provided feedback. That's been very helpful. And I'm going to ask that any additional feedback for the sections that have already been sent be provided by tomorrow. Again, the goal is to post everything by the entire report on Friday. So if you can provide any feedback by tomorrow, that would be helpful. Does anyone have any questions about this process? Okay, thank you. That's all I have to say.
Wait, Linda?
Okay.
Yes.
Dissents, as I understand it, we simply provide those to you approximately September 15, and those will be attached as exhibits or addendums.
So the plan, yes, the plan is to, before, when the report goes to the board, after hopefully the working group will approve it on the 10th, and any dissenting opinions will be attached as an appendix.
Thank you.
Mm-hmm.
Okay, any other questions for Linda? Not seeing any. Stephen Fleischman?
Yeah, I don't want to spend a lot of time on this, but I wanted to move for reconsideration on the vote at the last meeting to allow 49% paraprofessional ownership in law firms. It was a close vote. It was 9-5. The two bases for reconsideration. Number one, 2 days after our vote, there was a story in the Daily Journal.
So Stephen, I'm sorry to interrupt, but I just want to make sure that Brady doesn't have something he wants to tell us regarding procedure before you go forward.
I can speak after, or whichever you'd prefer, Justice Petro.
No, I just want to, if you think it would help inform Stephen, then feel free to speak. If it doesn't matter, then wait.
Well, I will point out we can't have a reconsideration vote on that item because it wasn't agendized. Government Code 11125 requires us to post to the agenda anything we're going to be voting on 10 days in advance, subject to certain exceptions that aren't applicable here. So I'd encourage Stephen to proceed, but to put this in
well, Brady, it seems. Go ahead.
Hold on. Because, Leah and I had received your email over the weekend. I think it was sent either late Friday or Saturday. I didn't see it until Sunday, at which point it was too late to do anything in regards to the agenda. Leah, I thought, though, based on our back and forth, that there was an opportunity for Stephen to do this today. So I just want to get some clarity on what we can and cannot do before we have further substantive discussion.
Well, I am not sure if I was confused or confusing in my conversation with you. I didn't think we could actually take a formal vote on it. I did think we could have discussion, and depending on your desire, Justice Petru, we could put it for a vote on our very last meeting on the 10th. It will create some real challenges for finalization of that particular section of the report. But I certainly thought we could talk about it and discuss it now. But I think if I gave the impression that we could take a formal vote on it, I was wrong. So
okay. And it may well have been confusion on my end. And so with that, Brady, is there anything else you'd like to say in regards to that?
No, and that would, with the Leah's stated concerns about the timeline, that is a legal alternative if the decision is that people want to take another vote.
Okay, so Stephen, with that and with your prefatory comment that you don't wish to take a lot of time today, and obviously we're not going to be able to take a lot of time at the next meeting because we are already going to be very jammed up. It probably is worth it for you to spend a little time now with your concerns. We can take some feedback from other people if they would like to give it. And then we can, move forward, make a decision about whether to put it on for a vote. So take it away.
All right, so two things happened. Number one, 2 days after our vote, there was an article in the Daily Journal in which the chair of the Assembly Judiciary Committee expressed concern for the first time I'm aware of publicly about what our group is doing. I asked Linda to circulate that to everyone. I hope everyone had a chance to read it. I don't think it's a coincidence that We've been doing this a year and a half, and the first time that person has spoken up was after we took what was probably the most controversial vote on 5.4. Number two, I went back and looked, and we had been proceeding on the theory that the other group, the sandbox group, can make a recommendation to the Supreme Court to change the rules governing attorneys, and that would be Rule 5.4, which prohibits non-lawyer ownership in law firms. I went back and looked. The charge to the sandbox group, however, is limited to 5.4 regarding fee sharing, which is 5.4A, not 5.4B. So our recommended rule will not have any effect unless 5.4B is changed. And the sandbox group is, at least on its face, not charged with changing or making recommendations for 5.4B. Now, whether they usurp that jurisdiction and do it anyway, I don't know. And I'm sensitive to Greg's concern that this, look, the Supreme Court will figure all this out. But I just cannot emphasize enough what a political lightning rod our vote on 5.4 will be. When this thing goes to the legislature, the plaintiff's bar is going to be against it. The defense bars.
Let me jump in just for 1 second, though, because I do think we should probably take a straw poll after we've taken comments about this. But again, we're not going to, I don't get to decide, well, I don't get to decide anything because I'm not voting on anything. But you all don't get to decide what goes to the legislature or not. Okay, just because something is included in our recommendation does not mean that that is what's going to necessarily go forward. Leah's already gone over the steps and all the opportunities for input and all the rest of it. Again, we're charged with what we think is the best program. Maybe people want to rethink this, that's fine. But I just want to caution us because not only, there are many people, both on the working group and in the public comments, that make it sound like we get to decide what's going to go to the legislature. We don't. And I want everyone to understand that.
I understand your point, Justice Petru, but what I was going to say is we have to balance the lightning rod versus the benefit of that rule. And I'll let Amos defend the rule, but at the last meeting, he was pretty clear. Our program can go through without this rule. And the only justification for allowing paraprofessionals to have 49% of the profits of cases that they're not licensed to work on, like civil, criminal, immigration, was to, encourage new business models. So it was a close vote, and I want to give everyone the opportunity to reconsider it. I know Steve Hamilton was willing to second it, and I know Carolyn wanted to be heard on it.
Okay, Carolyn, speaking of you, your hand is raised.
Okay, this is where I wanted to chime in before. We heard I'm going to talk about two things and subparts in between those. I want to talk about what's not going to work and what is unfortunately going to work after we make this recommendation. And I respectfully disagree that the importance of what we're doing is not absolutely significant. So what's not going to work is including for-profit models in our program. It has generated, as you heard, furor in the legal community. And it opens up this program, which is not designed to talk about for-profit models per se, into a criticism beyond words. And you'll get public, I was heavily involved in ATILs. We got 3,000 comments on issues like 5.4. It is not something we need to touch or want to touch. And it puts this whole program with all the things that we've talked about. I've disagreed and I've agreed with a lot of things, but it will put the entire program in jeopardy. Because those recommendations are taken very seriously by the public. So that's what's not going to work. The inclusion of 5.4E3, one little sentence, may kill this whole thing. It's not needed. What's going to work, and again, I think I have expressed this concern and others have expressed this concern, is if you add 5.4 and it's going to go into the sandbox, because the sandbox is fairly well along in its discussions. And there's a lot of people on the committee from outside California who are involved in Utah, involved in Arizona. The Utah, one of the Supreme Court justices of Arizona is on that committee. They're discussing applications, the format of how people will apply to this program on Friday. In Utah, 48 corporations have already been approved, not mom and pop places, but corporations, some of them huge, and in areas well beyond the Utah Paraprofessional program. The very, very large corporation that many of you may have read about has applied in Arizona. These are called alternative business structures. So they take the paraprofessionals, they take these alternative things and they turn them immediately, and they've turned them, that's only since June. I don't know what in Utah, it may be more. So this was rejected by the ABA since the 1980s. This was rejected by the California Ethics Group, and Greg can correct me if I'm wrong. This was not included in 2018. This was not in ATIL's report and finalized in 2020, but the preliminary came out in 2019. They said this needs data. This doesn't need an up and down vote. They said this should be studied based on further data that was going to come from those applicants, not just the up and down vote. So this is something that if we recommend it, is going to be taken very, very, very seriously. And then the last thing, this is a little kind of a wonky thing, but this kind of demonstrates the impact that this is going to have, the reality. You know, we can say, oh, non-attorneys can own part of this and it's important to justify and build up the program, but here's what's really going to happen. And I contacted one of my colleagues who's a brainiac economist, and he said this really fast before in one of our public comments. And this is why 5149 has been voted down forever. If you have a corporation or an entity that has a 51% ownership of attorneys and 49% ownership of one paralegal, you split that to 17 attorneys own 3%. So you got 17 attorneys who own 3% and one paraprofessional owns 49%. That paraprofessional needs one person to defect to get a vote, one person. So in essence, if it's a money thing and they make a decision based on a profit motive thing that, you know, we're going to tweak this, we're going to make more money for our shareholders, one person is going to flip and make that. So the paraprofessional has all the power. And a corporation, if you can get one person to side with you, which, you know, you got corporations with 2-3 people and 2 people do it. And, you know, okay, this is absolutely guaranteeing that the non-attorney will control that company. Period. End of story. So, yeah, no, this is not needed. This is foolishness. This is not, there's an economist on the sandbox committee. That's the people who should be discussing this, not us. Thank you.
Erica?
Hey, thank you so much. First of all, I just want to appreciate Steve Fleischman, because I think what I've known him now through this process, and in the beginning, it seemed like he was less supportive, and the fact that he's, you know, expressing concern, and I hear like the passion and the caution in his voice, to me indicates that, you know, I mean, he's come around, he's supporting this process, and he's hoping that it will pass through the legislature. I do want to caution us though about basing our vote on a newspaper article. I have been able to meet with Assembly Member Mark Stone, and he's, I think, very thoughtful and hardworking. I talked to him about CJP issues, and I have no doubt that the legislature will study this when it gets there, which is, we're in early days because it's not going to happen until next year at the earliest. And I think that the legislature will have more information. And so he made a comment to the newspaper. I don't think we should base a vote on that. And I'm actually sure the lobbying's already started with respect to electeds. And then I know I listened to what Carolyn said and what the public commenter said, but I also want to express caution when we talk about something being for profit and whether it's nefarious, because I was a partner in 2 law firms and I was in it for the profit. I was a Wiley Manual awardee and did a lot of pro bono, but you know, law firms are in it for profit. And so I worry that we're making a straw man argument by painting paraprofessionals as being less ethical, more nefarious, more Machiavellian and manipulative because they'll take one person to flip a vote. I mean, there's going to be lawyers in these law firms too, and the lawyers hopefully will be ethical and they won't be flipping their votes. So I just kind of feel like we're not really giving a fair shake to people who would be paraprofessionals. And I so appreciate what Claudia said and what Fariba said and what the woman who spoke on behalf of LDAs. I think we have to remember that these people are going to be people who, for their own reasons, decide that they do not wish to practice law. They may be women, they may be minorities, they may be people who speak the language of the people that they will serve, and we can't paint them as bad and, you know, lawyers always good. And then also, you know, we have voted on this already, so I just wanted to throw that in there as well. So thank you.
I'm just trying to see, Stephen, if anyone else wishes to make comment before I come back to you. I don't see any other hands. Go ahead.
Erica, thank you for your kind words. I think you and I have a philosophical difference, and it's this. You think paraprofessionals will be as good as lawyers, and I agree and think that's the problem. And what I mean by that is there's been a lot in the news about one lawyer in particular abusing the rules. And whatever rules we create are going to be abused by paraprofessionals just as they are abused by attorneys. And so, you know, I did a lot of legal malpractice work. I know Julia has also, and I've sort of seen the worst side of the profession. And so that's where I'm coming from. But specifically with regard to this rule, you and I spent dozens, if not hundreds of hours in civil and employment subcommittees deciding paraprofessionals should not practice in those areas. What is the justification for allowing them to get 49% of the profits from those cases? I just keep coming back to that. We decided they shouldn't be able to practice in those areas, but we're going to allow them to get 49% of the profits from an immigration law firm or from a law firm that does employment work. And I still don't get it.
I also did medical and legal malpractice work, and I'm not sure I would say those lawyers were the worst of the worst. I think that, you know, people make mistakes, but I also trust the lawyers who will be part of that law firm. And if they choose to enter that relationship and they have to be bound by the ethical rules, I don't think that a paraprofessional could run amok because the lawyers are going to be there as well.
Kimberly?
Unfortunately, I wasn't able to make the last meeting, so I apologize because I did want to make comments there about this. And so I'm going to make them now. You offered me the opportunity now. So I did want to say in our world, in the Department of Consumer Affairs with our boards and bureaus, you know, this does come up. And in the corporations code, it does cross over where you can have a medical corporation that is owned by 51% physicians and 49% of many different other professionals, healthcare professionals. And in those entities, they do spread the income across those other individuals. So I don't think in the legal world it will be any different than it is in other entities. So my vote would have been, if I was voting, then it would have been for it as well. But I did want to make sure that you understand there are multiple other corporations out there that do it just like we're recommending.
Kimberly, can I ask you a question about doctors?
Yeah.
My understanding of what you just said is those other 49% are other types of doctors very carefully specified by the legislature, like osteopaths. They're not nurse practitioners.
They're nurse practitioners, they're registered nurses, they're psychologists, they're chiropractors, they're multiple other different individuals.
All right, thank you.
Yeah. And Steve, I can send you the corporations code just so you can see how that's mixed.
No, I tried looking at it and my eyes glazed over.
Okay.
Thank you for your honesty, Stephen. Carolyn.
Yeah, just to follow up on that really quickly. One of the things that really kicked off and started this access to justice movement were CPAs in London who wanted to own law firms. And again, they saw the profits, in these international law firms. So as one of the things to consider also, I do recognize that we have said paraprofessionals in our rules, but let's not be naive. Behind the curtains are CPAs and CEOs of businesses who are not used to practicing with ethical obligations. So just keep in mind, this started with CPAs at big firms wanting to own a personal law firms. It's been that way forever. So that's the history of this change. This history goes back 30 years of trying to change this. And it has been decided that, good lawyers, bad lawyers, that's not the way we have the legal obligations and the ethical choices under 5.4, very carefully written for decades. So you just got to understand, we are changing decades of law and rules of professional conduct that we haven't really even discussed. And again, right on the heels of this are huge corporations with CPAs and all kinds of other non-legal professionals. So it's not just the equivalent of doctors and nurses and psychiatrists and that kind of thing. It's going to go, this is going to lead to something else. Thank you.
Okay. Trying to see if there are any other hands. Not seeing any other hands. Linda, can we just take a straw poll? And the question is, there's not a formal vote on anything. The question is whether this should go on the next meeting agenda for reconsider, essentially for a new vote.
Sure. Bashan?
Yes.
Brynelson?
Yes.
Belmeth?
No.
Fleischman?
Yes.
Hamilton?
Yes.
Hartston?
Yes.
Kirkmeyer?
No.
McRae?
No.
Olvera?
No.
Robinson? I guess she's not back. Judge Rubin?
No.
Shining?
Yes.
Sarush? Reba, are you there? It's not. Spiro?
Yes.
Torres Ambriz?
Yes.
Judge Wiley?
No.
And Judge Yu?
No. Thanks, Linda.
3, 4, 5, 6, 7.
I count 8 to 7.
5. Yeah.
I'm sorry?
It's 8
I
to
counted
7.
8 to 7, yes.
Okay, that's an awfully close. I think
Ariba's back.
Oh, Fariba.
I'm so sorry, an emergency came up, I had to run out. Are we voting on Steve's?
we're voting on whether to put this on our next agenda because we cannot take a vote today since it was not on the meeting agenda. So the question is whether it should be vote should be reconsidered. I know you had to step away. If you'd like to vote one way or the other, you're welcome to. If you'd rather not, whatever you prefer.
In terms of just putting it on the agenda for discussion, that's it?
I'm
For
sorry?
Put it on the agenda. The proposal is that we're voting on is to put it on the agenda for next meeting for discussion?
No, to vote. We had the discussion today.
Yeah, I was here.
Yeah, and so the question is whether to let it lie or to put it on the next meeting agenda for a vote.
And if I say no, we let it lie, correct?
Correct.
No, thank you.
All right. So Linda, what is the current tally?
It's split 8 to 8.
Okay, which to me means I think it needs to go on the agenda. I think this is going to be problematic for us for timing and certainly problematic for getting things together for the board. Linda and Lee and I can talk offline about whether there's what we can do and how to make this happen. And I will say, Erica, just 1 second. I will say there was discussion today. And so while I'm not going to say people can't discuss next time, I would encourage people not to make the same arguments repeatedly because we're all here and we heard it. And I appreciate the fact, I know that when there's a split vote, I can vote, but when it's this close, I think it needs to go on. I just want to be clear also that everyone understood that a no vote means let it lie and that a yes vote means put it on the agenda for a new vote next time, correct? Okay, Julia, your hand is raised.
What happens if there's 8-8 in the final vote?
Then I vote.
Okay,
We're actually taking a formal vote and it's split. Then I have to do the tie-breaking vote.
okay. Thank you.
Ms. Rubin?
I haven't heard from Mr. Dewar, but just in terms of our process just now, this was just really kind of an advisory straw poll to the chair. This wasn't actually voting on whether or not to put it on the agenda, because that also wasn't on the agenda to vote on.
Right, exactly. I mean, it's a chair and staff decision what will go on the agenda, and so this is sort of all into the realm of the chair report still. So, but we want to make sure that that both proponents and opponents will have fair notice that this is going to be reconsidered, and that will be
Right, and I understand that it's my prerogative whether to what we're putting on the agenda, and so it was really to help me decide whether that should happen. And my decision, given how close it is, whether it is to put it on.
And I agree with you on that, if it matters.
It does matter, David.
Of course it does.
Okay. All right. So now it's 11:47. I certainly would like to get something more done before we take a break for lunch, and also to not have it skew so heavily, towards a long afternoon session. I believe, let me pull up my agenda. I believe that the next thing up was the recommendation from the Housing Subcommittee. Leah, is that correct?
Well, yes.
Okay. So unless there's anything else that we need to do right now, I think we should roll into that.
Okay, I think that means I'm on. Unfortunately, Judge Harper could not join us today. He's the chair of this committee. But we did have 2 recommended resolutions that we discussed briefly. I don't think it was last meeting, maybe 2 meetings ago, but we didn't have time to complete the discussion and vote. So there are 2 recommendations from the Housing Committee that I will briefly highlight again, and we can continue our discussion and hopefully vote. And just to remind people, rent control, subsidized housing, and mobile homes were issues that came up for the Housing Subcommittee that raised some concerns, particularly from legal services and consumer advocates, that these are more complex than the run-of-the-mill unlawful detainer case, that specialized training is necessary, and really specialized disclosures to consumers who are hiring paraprofessionals related to cases that involve rent control, subsidized housing, and mobile homes. And I'll also say it was considered seriously to exclude one or more of these from paraprofessional practice because of the complexity and because of the availability of legal services in some of these cases, at least in some jurisdictions. The Housing Subcommittee, instead of excluding these, indicated that there should be specialized requirements in terms of training and disclosures. So the first recommendation there is that for landlord-tenant matters on behalf of tenants involving rent control, subsidized housing, or mobile homes, that paraprofessionals be required to advise clients about the specific risks and complexity of these cases and provide specific information about the availability of free or low-cost representation by an attorney in their county, including contact information. And that the risks disclosed must include that the tenant may lose their subsidized housing, mobile home, or benefits of rent control. And I'll say we did hear from several people in the subcommittee, including several people from legal services, that had serious concerns if these requirements weren't included, and the Housing Subcommittee agreed. So do you want to take these separately?
I think so.
Okay, so with that, I think we can have further discussion, but I would like to move for.
I see Sharon's hand up.
Please, Sharon.
I was just wondering if you had testimony that the risks were so great, why were these not excluded altogether from the program?
Yes, so fair question. I think rent control was not excluded because that is very prevalent in several counties, and that would exclude too much, really make it, and that was something that we thought people could be trained on. Subsidized housing, which was a much closer call. I think several people were concerned and in particularly felt that at least in some jurisdictions, legal services are available for free for cases with subsidized housing. I think the issue was we didn't get comfort that that's true statewide in all jurisdictions statewide. But it's clearly in some jurisdictions, people may be better off and should be informed of the option of getting free legal services with specific contact information, and that there may be availability for free legal services with anyone who is at risk of losing subsidized housing.
Sorry, can I ask a follow-up question? What you were saying about providing the contact information, wasn't that voted down for the whole program last time?
Yeah, so very good point. So this is something we discussed last time when this was up, because it was pre-vote for the other one. I think there was the Housing Subcommittee is making a specific recommendation that in these specific types of cases, contact information be provided. But that was, although it was discussed as a potential broader requirement for paraprofessionals generally in all cases, that was voted down. This is a specific recommendation by a Housing Subcommittee on specific case types. Kimberly?
Yeah, obviously I have the same concerns with the contact information being required, just because I'm not sure that it's available. If I hear from the professionals on this group that is easily available for individuals. And then I did have one question, Amos. It says specific about the specific information about the availability of a free or low cost. Specific is kind of a term that is not really identified. What is that specific information? So I just don't know if it needs to be more clearly laid out for individuals. That term is kind of loosely used.
Okay, so let me take the first part of your comment first. So another distinction besides the risks that were considered for changing the recommendation from the broader recommendation, sorry, that's a mouthful, but in requiring paraprofessionals provide more specific information, including contact information, did rest on two additional factors that were considered by the Housing Committee. One is the timeline of unlawful detainer cases. They're very quick. And if a consumer, a defendant in an unlawful detainer case decides to hire a paraprofessional, they may have limited time and availability to search for and find an attorney. And in these cases, there may be a free attorney that's available to them that it may be just different fact circumstances given what's at risk and the timeline involved in these cases. And as far as the specific, I think your comment about the use of the time specific, I think, again, is to distinguish it from just general comment that legal services may be available or legal services may exist. What we've found is that there are not, it will not be too burdensome. We discussed the burden and at least specific services, free legal services or low cost legal services for subsidized housing and mobile homes. That's not a long list of providers. And for most counties, it would be well known to any practitioners in that area. And if anyone else on the Housing Subcommittee wants to comment.
I do want to comment. I also just wanted to point out, add to everything that was said, Amos said, was that it's a balancing, right? So because of the short timelines and the importance of the issue included or addressed here, which is shelter, and the fact that the outcome is so dispositive, you're out. When you balance that against the burden that's put on the paraprofessional, I just think there's no question that we should require that a list of these resources be provided. And my position is exactly the opposite with regards to other areas, though, because, for example, family law, if you want to modify your child's home, you have time to research it and find other resources, and we shouldn't put that burden on the paraprofessional. That balancing, to me, that balancing fails on a broader base.
Ira?
Yeah, I just noticed something about it. I'm in favor of this, but it near the end, it says, third line from the bottom, representation by an attorney in their county. Now, there's plenty of communities where a court is, and there might be a low cost or free lawyer available for that court, but the lawyer is in the next county over, which might not be very far away. So somehow I'm trying to think how to change this quickly and easily, and I can't at the moment, but I think it needs to be changed. In other words, it's the services that are available in the county, not that the attorney has to be in the county.
Carolyn?
Okay, so I think this is, well, first of all, I think I voted against this in general. I can't remember, we don't think we have the minutes for July, but I'm in favor of all these kinds of things. More notice is something I'm incredibly in favor of, and I think I tried to argue for that when we talked about the written disclosures in general back in the rules discussion. My specific comment here is that if this passes, it should include references to private attorneys, because there are more than enough. There are very good attorneys available to deal with this. In particular, with regard to mobile homes, in 2019, the Friendly Village Mobile Home Park, huge mobile home park in Long Beach, after a good amount of litigation, serious litigation, resolved in a major settlement that helped all those people, really recover the value of their homes and more. So, so I think this should refer to, contingency fee lawyers, consumer protection lawyers who will do this for free with absolutely no cost to the person who's harmed in all these kinds of things. Similarly, with tenant disputes, oftentimes there's mold problems and uninhabitability problems. It's very easy to find a lawyer to represent you at no cost in these kinds of things. So just like I think that should have been in the other rules that we did, if we're going to suggest to people that it's quote unquote complex, what that means is you can find an attorney for free who's going to walk through these, these regulations. And I just don't know how you can teach a paraprofessional to do that with 3 hours of training.
So I would like to move for this first resolution that's on the screen to be adopted.
I second.
It sounds like there may be some friendly amendments in terms of like the term specific, or Ira or Carolyn, your comments. If you have specific proposals, if you'd like to make them, or maybe we can have further discussion or a vote.
And Amos, just to be clear, before you actually moved and for Eva seconded, I moved the language about in their county based on Ira's suggestions. So now in their county, it comes before this attorney. So I just want to be aware that you saw that in terms of what you moved.
So
I did.
I'm fine with that as well as a friendly amendment, if you will.
Yeah.
Any other discussion?
Yeah, I'm going to surmise, Linda and Amos, that my suggestions will be ill-taken by the group. I just have a hunch. We could do a straw poll, but I really don't want to waste everybody's time. I'm going to vote no, and based on the reasons I've explained, not because I'm against these kinds of protections, but for other overarching reasons. So unless people jump up and down right now, it may not make any sense for me to make an amendment and waste time.
I will note, Carolyn, that I have a similar objection or opinion with respect to 1.4.3. So that is the general notice of alternatives. And I'm happy to talk to you offline about a potential dissenting opinion. One possible solution, by the way, is for the bar to put together a list of alternatives. And then the paraprofessional can provide a link or something like that to.
Okay, but let's try to stay focused on this, on the what's in front of people right now.
Fair enough.
So there's a first, there's a second, it's been modified. Is there any further discussion or requested amendment? I don't see any. So Linda, you can go ahead and take the vote.
Okay, Bashan. Sharon? Are you there? Maybe she's not there. Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Ted Rubin, Shining,
Respectfully no, for the reasons discussed above.
Sarouche,
Yes.
Spyro,
Yes.
Torres Ambriz,
Yes.
Judge Wiley, Judge Yu,
Yes, thanks, Linda.
the motion carries.
Okay, so Amos,
Yes, so the second resolution, again, we briefly discussed this previously, and there was some comments, particularly about the jury trial issue. So what came up in the Housing Subcommittee is that demanding a jury trial in unlawful detainer cases is a important thing to be trained on. But paraprofessionals will not be able to represent clients at a jury trial. So there may be either a conflict of interest or maybe not full understanding of the importance of demanding a jury trial when filling out the answer. And initially, even if the paraprofessional will not be able to represent a jury trial. So we thought that it was important that there be specific information and required trainings regarding the benefits of demanding a jury trial in unlawful detainer cases. And also, as noted, because of the complexity and risk of issues regarding rent control, subsidized housing, and mobile home issues, that we wanted there to be specific training on those as well. So the resolution is to require or to recommend to the Oversight Committee to ensure that paraprofessional education programs include both required trainings about the benefits of demanding a jury trial and regarding rent control, subsidized housing, and mobile home issues. Stephen?
Yeah, I was opposed to this at the last meeting, and I asked the judicial officers to talk to their friends on the bench in LA about what's happened in LA with the explosion of jury trials and unlawful detainers. I'm wondering if any of them have taken that opportunity and want to comment on that. If not, I'll state what
I
my
don't,
position is.
yeah, so I'm not going to report on, and I appreciate that, but I'm not going to report on conversations with judicial officers elsewhere. I think I think we all know that there are many, many unlawful detainer cases across the state in all counties and places where there is a push for jury trials. I don't know that I have much to add, though. Judge Yu, I don't know if you wish to chime in. No.
Well, then substantively, we're not taking a position. First of all, paraprofessionals will be representing tenants and landlords. We did approve the representation of landlords with 1 or 2 people. We shouldn't be weighing in on whether jury trials are a good idea or a bad idea. What the training should be doing, and what this should say, is regarding the prosecution and defense of unlawful detainer cases, including the completion of judicial counsel forms. The judicial counsel form requesting a jury trial is UD 150, and it's box 3. It's really simple. That's all we should be saying. We should not be weighing in on a controversial issue like this. And to repeat myself, in LA Superior Court, which is the largest trial court in the nation, 50% of all jury trials are unlawful detainers. That has caused a huge burden on the court, and I hope that doesn't go statewide.
And then you've got some hands, Amos.
Julia?
Yeah, I just wanted folks to know that after this, we will be presenting from licensing and talking about the number of hours that we have recommended for this subcommittee. But I do agree that it's not going to add a great deal of educational requirement if we could agree. I mean, as they begin to create the curriculum, that it is a form notice of why requesting a jury trial has an impact. I think that in order to fully counsel a client, it is important that a person be informed of what their rights are. And if they have a right to a jury trial, I think that's a given that should be included. Nevertheless, when we get to licensing, we have a particular number of hours that we are recommending for housing and that subcommittee. And the specific method by which to teach this can be talked more about in licensing if you want to weigh in there. But in terms of requiring this, I think that it would be malpractice to not educate a consumer or your client about access to a jury trial.
Carolyn?
Okay, so I think Ira is ahead of me.
Oh, Ira, thank you.
Number one, it's important. This is particularly important. Jury trials are particularly important for unlawful detainer cases, more so than a lot of the other cases the paraprofessional might be working on. A lot of them don't. But anyway, it's particularly important. And it's not always obvious why it's so important for in unlawful detainer cases. And I also think that if we, I disagree with Steve. I think that if we identify something that's very important for the people that's supposed to be protected and served by this program, that we can and should say so. And this is one that is. And thirdly, we've had this debate before, but the only interest against jury trial demands for tenants in an unlawful detainer trial are two: the landlords, because they're more likely to lose, and some judges, because it causes a lot more jury trials and more work and more headache for the judges. Well, that's not supposed to be part of, with all respect to the judges on our working group, that is not one of the interests we're supposed to be serving. If there should be more jury trials for the people we're supposed to be, whose interests we're supposed to be protecting, then that's what should happen.
Well, just to be clear, I think the other concern that was discussed in the Housing Subcommittee was that paraprofessionals will not be authorized to represent tenants at jury trials. And so there may be either a conflict or misinformation about how to advise the client. So that's an additional reason, I think, at least was discussed. Carolyn?
Okay, so super quick again, and I don't want to insult any of the lawyers on the committee because you probably already know this. But in unlawful detainer cases where you have a slumlord, where you have uninhabitability, whether you have mold issues, whether you have a harassment, there are many ways, importantly, to bring civil actions. And you only have like I said before, you only have 3 days. That changes the complete character of the case. It causes it sometimes to be transferred to a civil case. And it is enormously important if you have that kind of thing. There is a Department of Housing also that you can call and handle these things, but they don't bring civil lawsuits. So again, I'm against generally the inclusion of the way we've done this within court, except for jury trials. The other thing I would mention that I haven't mentioned also is if you're an attorney and you take a case and you know it's going to be a jury trial, you prepare it as if you're going for a jury trial. So that's going to take a lot more money and a lot more time for people. just to say, oh, I'm not going to do a jury trial. You have to know what is going to be impacted if this gets to a jury trial. Otherwise, again, you are really, really not representing your clients. So I would just say, I would add to this friendly amendment that it should say jury trial and unlawful detainer cases and civil cases involving uninhabitability, and maybe even referencing Department of Housing citations. I would add those two things.
And Amos, it's honestly going to be up to you in regards to, presuming you're moving, what you wish to accept as friendly amendments. And of course, you still have a couple of hands.
Thank you, Stephen.
Is it me or Ira?
Let's go, Ira.
Oh, all right. Maybe I'm misunderstanding what Carolyn says, but you cannot bring an affirmative case. A tenant cannot bring an affirmative case for uninhabitability or anything else in an unlawful detainer case. Those are separate cases, and they're not covered by this resolution we've got here.
I'm not an expert, Ira. I don't do landlord tenant per se. Okay, but what you do is you file a civil case that is then either combined or jointly, conjoined in some way. Or,
no, it's not. It's okay. They're not conjoined. They're not combined.
Okay, it should still be mentioned because there's something here that may be waived that is important if you have a slumlord. It's a really important and powerful tool, and it needs to be. You need to be able to stand up and say, "You're a slumlord. This is uninhabitable." There's remedies for that.
You can still do that in the defense of the case. It's an affirmative defense, and it doesn't need you don't waive an affirmative lawsuit brought later by not making a defense in this case, in the unlawful detainer.
You don't know if they settle keys for cash on the in the hallway.
So okay, so let's go. Stephen, do you have another comment before?
Yeah, Amos, what's wrong with the language? Why not make this?
Sorry, I didn't hear that.
What was wrong with the language I proposed a few minutes ago?
What language?
Regarding the prosecution and defense of unlawful detainer cases, including the preparation of judicial counsel forms.
Because I don't think it's necessary. I think that is clearly going to be included in the training. What this resolution is highlighting is the need for specifically calling out the benefits of demanding a jury trial for tenants.
And what are the benefits for the landlord?
Because paraprofessionals will not be authorized. That's what's being highlighted. So this is not intended to be a complete discussion of what training is required. This is calling out the specific issue of the concern that paraprofessionals will not be authorized to represent clients at trial, either jury trial or bench trial. And the importance of demanding a jury trial is something that needs to be communicated. And I understand that certain people have concerns about jury trials, but it is a constitutional right. And it is something that if we are authorizing practitioners in this area, that at least the Housing Subcommittee is recommending that it be specifically identified as needing specific.
Well, since you brought up the 7th Amendment, can someone tell me why there's a right to a jury trial in unlawful detainers when the relief sought is equitable?
They're not equitable, and that's
seeking possession of the premises.
No, it's been held. This is a long-standing rule that there is a right, not rule, long established for many years that there's a right to a jury trial in unlawful detainer, and it's way too complicated a discussion for us to go into.
Yes, I think yes. Let's move on.
So I would like to move for the resolution on the screen to be adopted.
Do you have a second?
I can second.
Okay, and I presume there's no amendments that you're making to it. Is that correct, Amos and Fariba?
Correct.
I agree with that.
Okay, then Linda, you can go ahead.
Sorry, Bashan? Yes, she's not, still not here. Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
No.
Hamilton,
No.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin, Shining,
No, it's not enough.
Sarouche,
Yes.
Spyro,
Yes.
Torres Ambriz,
Yes.
Judge Wiley,
Yes.
Judge Yu.
Yes. Thanks, Linda.
The motion carries.
That is all from the Housing Subcommittee.
Okay, then I think this is a good pause point. Why don't we take a half hour? It's about 12:15. Let's resume at 12:50, okay? Thanks very much.
Thank you. 15.
Wait, did they say 12:30?
Oh, 12:15.
No, what I
No,
said
come
was
back.
it's currently 12:15. We'll resume at 12:50.
12:50.
50. Okay. Thank
Yes,
you.
50.
Thank you.
Thank you, Claudia.
Okay.
And
we're
do
back in
any of the
session.
attendees wish to make public comment? If so, please raise your virtual hand. I don't see any, so let's continue with our agenda. I believe the next, oh, I just lost my page. That's not helpful. Which group? Yeah, licensing. Thank you. So Linda, could we get the licensing, whatever we need to have up?
Yes, I'm bringing that up now.
And I do see that Jeannie Harrison has a hand raised. So if you could allow Jeannie Harrison to speak and then we'll resume.
Okay.
And we're going to need to have a 2-minute limit this afternoon. We're going to have a real problem getting through the remainder of our agenda.
Okay, Ms. Harrison.
Thank you. Can you hear me? Yes, thank you. Sorry about the delay. I just wanted to make the point that while I understand that this group is not able to make an up or down vote on whether there is potentially going to ultimately be a paraprofessional program approved by the Board of Trustees, this group does have the capacity to vote no, as I mentioned in my original comments, on the proposals that are in front of it now. I wanted to make that point. Thank you for hearing me.
Thanks very much. So we're turning to licensing. And who is leading this discussion?
I am. Julia.
Take it away.
Okay, so we have reviewed the subject matter proposals, and in our last meeting, we reviewed all of them and voted on them. For consumer debt and general civil, I want to say there were 2 proposals, and for housing, there were 3 recommendations. So consumer debt and general civil, we had a proposal of a mixture of 6.5 hours in terms of education and units. There was another recommendation of up to 9.5 units. We deliberated and agreed to the 6.5 hours, thinking that that would be sufficient for the educational requirements. And it was part of the consideration that something like consumer debt and general civil, we may have a candidate who wants to pass an exam in not just one practice area, but in more than one. So that would lend itself to having potentially another practice area that they could hopefully finish in a year, which is what has been our goal in structuring the licensing and the experiential requirements. Then for family, children, and custody, this has become the first one that we really looked closely at. And it was also the one that we, after spending a great deal of time, much of which was led by Stephen Hamilton, we have this as the practice area that has the most number of hours, units, I should say, which is 13. So 13 is the highest in that regard. Is Stephen here? Does he have anything else he'd like to say about that?
Mayor, no further comments.
Okay. So then for employment and income maintenance, we have 3 units for administrative agency procedure. So for example, that might be something that a person who could test out of or take the courses could do consumer debt and general civil, as well as employment and income maintenance. Then for housing, we had 3 proposals, and based on what we looked at, one was for 5 hours, one was for 14 hours, and one was for 11 hours. And we picked the one in the middle because based on what the topics were, there's not, I mean, and part of those were discussed today when we voted on what Amos proposed for housing, is that I think that some of the different types of items and topics will naturally be combined and taught together. And so I'm not sure that we just felt like it wasn't going to supersede the amount of units that even family law was going to require. So we didn't believe that the 14 units would be necessary. Judge Harper voiced that as well. And so as a group, we voted for the recommendation number 3, which was 11 units in order to take for your house, to prepare you for your housing exam. And I think, isn't that it, Linda?
Yes, that's it.
Okay. Sorry, I'm just trying to pull up my screen here. Okay, so do we need a vote? What do we need here?
Well, if they would like to have discussion, and I see
Sure.
Amos has
I
his
see
hand
Amos
up.
has his hand up, yes.
So I have concerns about how these recommendations were developed, but I'll hold on that. And what I'm wondering is if, because consumer debt and general civil and employment and income maintenance are not included in the proposed pilot, if maybe we could table those, because my understanding is neither the consumer debt and general civil subcommittee nor the employment and income maintenance committee have had a chance to discuss those. So I think maybe your committee, the licensing committee, looked at some staff recommendations. I don't think there was any input from any of the subcommittee members on employment and income maintenance. And I was on the consumer debt, and I feel strongly that this proposal is inadequate in terms of training for what was discussed in terms of the debt collection and creditor harassment. I mean, we discussed a lot of different statutes, a lot of state and federal law, and we voted that some of it should be excluded from paraprofessional practice because of how complex it was. So I'm just concerned that the subcommittees haven't yet had a chance to consider those. So I would suggest that maybe we table those and we vote on the ones for the practice areas in the pilot.
So is the practice area in the pilot only housing?
It's collateral, criminal, family, and housing.
I'll just jump in to say that while certainly that's more time sensitive because it is part of the pilot, I don't think that we can, disband our working group without having voted on these, because then we do not have a comprehensive proposal. And at some point, someone needs to vote on this, and it needs to be us. I would think, unless I can't see everyone because of the way my screen is set up, unless Leah, you disagree, I think that a vote needs to be taken before we disband on this. Is that your view?
I think so. I think so. Yes, there could be perhaps an additional resolution indicating that the working group feels that additional input needs to be sought. And I think, in fact, we say that in the memorandum that the State Bar would need to work with subject matter experts to finalize all of the associated curriculum, and that modifications may in fact be made. But maybe we could make it more explicit that those modifications could include changes to the unit requirements as an additional resolution.
Well, if consumer debt and general civil is going to be voted on, and if employment and income maintenance is going to be voted on, I think we should hear from those subcommittee members about their views, because I don't think those subcommittees had yet had a chance to consider these proposals.
I believe everybody had a chance via email.
Yeah.
There was not a meeting on the topic, but I don't want to have the suggestion out there that they've never seen the proposal.
So does the friendly amendment, is there a friendly amendment to the resolution include the statement, Leah, that this is all subject to the advice and counsel of the developers of curriculum with respect to each practice area?
Yeah, and these are in the resolution itself, it says they are minimum. They're minimum educational requirements. I'm just trying to see where we reference the fact that subject matter experts would be engaged.
Okay, if we are going to go forward on voting for the consumer debt and general civil, then I would like to open the discussion up to that practice group. I was on that, and I do think for debt collection and creditor harassment, the 3-unit is not nearly enough. And again, I'm happy to talk at length to all the different consumer protection statutes that we discussed could impact just even general advice about whether there's consumer protection statutes like the Rosenthal Act, there's a federal and state, on all sorts of things that touch. And we heard from a lot of practice area specialists about how complex it was. I think these recommendations did not come from anyone on the working group. I think they were staff recommendations. And again, because we didn't have an opportunity to discuss them as a working group, I suggest changing the debt collection and creditor harassment line item from 3 to 6.
I just want to clarify, we did get feedback from the Consumer Debt and General Subcommittee, General Civil Subcommittee, that was provided to the Licensing Subcommittee in their development of these requirements.
But okay, thank you for that clarification, Linda. The Consumer Debt and General Civil Subcommittee did not have a chance to consider staff's recommendations and weigh in together and discuss the educational requirements. I think if that had happened, these requirements would be a lot higher. That's my opinion.
Julia, you should feel free to call on the people whose hands are raised.
Okay, I'm gonna, Steve Fleshman.
I second Amos's motion to increase it from 3 to 6 units. I think we should just vote on it. I don't think it requires a lot of discussion.
I'm happy to entertain that unless somebody on licensing is, that'll just put it to 9.5. If you feel that strongly, Amos, if that will be the difference between up or down for you, I think all of this is subject to the recommendations and development of subject matter experts who will be developing curriculum. And if they really say that that's just too much time, we can, that'll be listened to. But I also think that right now we are looking this as minimums. But if that is what it's going to take to get Carolyn and other folks on consumer debt and general civil along, I'm willing to entertain that unless Stephen, Judge Harper's not here, and then Claudia can indicate whether or not they have any issues with adding an additional 3 units to the consumer debt and general civil.
And I believe you've had Carolyn's hand up. And
Oh yeah, I keep putting it up and down because I really appreciate really appreciate all the time in this, and because this is really important, and all the time, Julia, you've done this and your expertise in this thing. Does everybody need to get evidence? Does everyone in the program have to have the 3 credits of evidence?
Yeah, that's in the core. These are just a practice area. We've already voted on the core requirements for every person who's going to go through the program. So these are in addition to the basic core classes that they're going to have to take.
Okay, so just my points would be, yeah, I think it was 1.4 point. I forget that Amos, that I wanted more disclosure on all those notes if some statute someone was going to do that. Sorry, I'm hurrying. But again, I think I voted no on this whole group. So I may have voted yes on enforcement of judgment. Steve will remind me, but I'll vote no on this. Again, no disrespect to all the work that everybody's done. I am in agreement that this kind of thing needs to be strenuous, and I want to thank you guys all for your work.
Can I just interject one thing so that everybody can keep this in mind before Stephen speaks? Remember that all practice areas will include, this is in addition to these requirements, 3 credits of ethics and professional responsibility, including practice management and recognition and elimination of bias in the legal profession, 3 credit hours of pretrial discovery and evidence, practical and not just theoretical, 3 credit hours of court procedure, and 3 credit hours of court advocacy. Stephen?
My comment was had to do with the suggestion by Amos. I don't mind addressing this during this meeting so we can get the issue resolved and taking into consideration what the recommendations of that subcommittee are. That was always the intent.
So are you willing, as a member of the licensing committee, to accept a friendly amendment and make that 6 units as a minimum?
Yeah, absolutely.
Okay, Amos, you've won us over. Your friendly amendment will now be that debt collection is 6 units, which then causes this to be 9.5 units as a total subject matter units. Is that sufficient for you, Amos?
Thank you. Yes, for consumer debt and
Well,
general.
yeah, let's just focus on consumer debt. I don't want to start jumping around. I think it's gonna make us take more time if we're going back and forth. So do people have other commentary just regarding consumer debt and general civil?
I don't know, Julia, if you forgot to ask Claudia's input. She's also on the licensing subcommittee.
I just can't recall if Claudia was at that meeting. If she,
Okay.
Claudia, would you like to contribute now?
Thank you. I do not disagree with changing it up to 6 units. I'd like to have it adopted, so I'm good. Thank you so much.
Sure. Thanks for contributing. So is there anyone else who just wants to talk about consumer debt and general civil? Is there anyone who would like to have further discussion on family, children, and custody? Is there anyone who would like to proceed?
Can we take a vote on, because can we do it one section at a time? Could we do consumer debt and general civil? See if you have, can take a vote on that and then go to family, children, and custody and so on?
Judge Rubin has his hand up.
My literal hand, not my electronic hand. I did the name and gender change calendar for about a year. It was part of my responsibilities for about 1.5 years. I see it's got 0.5 units assigned to it. Do we know how many hours 0.5 units corresponds to?
Well, we think that 1 unit is an hour of class. Well,
Linda, can you answer that?
We've been working.
It's roughly 45 hours. It's 45 hours, 1 unit. A half, half unit, I'm sorry, it's half of that. So it's 22.5 hours.
So name and gender changes would consume 22.5 hours.
Not just of class time, that includes the additional anticipated out of class work.
I think the class time correspondent would be about 7.5 hours.
Fair enough. That's adequate to cover it. Thank you.
Okay, so do we have, is someone moving in regards to consumer debt and general civil?
I'll make a motion to approve if that's all right for me to do.
I don't see why it wouldn't be. Is there a second?
Second.
Okay, second was Steve Fleischman. Thank you. And Linda, can you take the vote on that?
Yes. So I'm sorry, it was Julia who moved and
Yes, Stephen
second?
Fleischman, second, yes.
Okay. Bashan,
Yes.
Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes, and thank you for the amendment.
sure, Kirkmeyer. Oh, maybe, I think Kim had to step away. McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Yes.
Spiro,
Yes.
Torres Ambriz, Claudia, Judge Wiley,
Yes.
Judge Yu.
Yes. Thanks, Linda.
Mhm. The motion carries.
So now, Justice Petro, you would like to talk about family and children in custody?
Well, what about collateral criminal?
Oh,
That's actually the first thing at the top. We wound up, we started to kind of dove into a discussion regarding consumer debt, but I do note that the first thing on this list is collateral criminal.
I move that we adopt the educational recommendations for collateral criminal being.
Second.
Okay, so that was Stephen Hamilton first and Stephen second. And Linda, you can take a vote on that.
Oh, I'm sorry. Can I just pipe in for very short, quick? So Linda did pass the educational requirements by myself and Ms. Bashan. So we did see that. And we were on the collateral criminal expungement team.
Thank you.
Thank
Should
you,
I take the
Jessica.
vote?
So we have the motion in a second, so are we now going to vote?
Sure.
Yes.
Bashan,
Yes.
Brynelson,
Yes.
Thelma,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Kirkmeyer,
Abstain?
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Yes.
Spiro,
Yes.
Torres Ambriz,
Yes.
Judge Wiley,
Yeah.
Judge Yu.
Yes, thanks, Linda.
So now it looks like we go to employment and income maintenance. And I don't know, Amos, did you have some discussion you wanted to have about that?
Well, I wasn't on that subcommittee, so I'd be interested to hear from members of that subcommittee if they had a chance to consider this.
Do we know who the chair of that was?
Erica.
Carolyn?
Sorry?
Was it-
Erica was the chair.
And so Linda did pass the educational information by us. And then I think we all sort of said we would look at it and get back to Linda. And I'm not sure if individuals did or not. I would move that we adopt this recommendation.
Second.
And Carolyn here, again, I just don't think these are enough. But it's, it's part of my in court. I just believe you can't get in court. You can't get in an administrative agency. This is workers' comp and EDD. So I just don't know how this can get done. So that's all.
I think workers' comp has been excluded from the program.
I was just going to say, we did exclude the things that we thought should not be handled by a paraprofessional. So I think we've covered that ground.
The resolution, see, went back and looked at the resolution and I've looked at some other things. So maybe we need to change this to reflect those things. I think it's gotten kind of lost in our resolutions, what we had in subgroups and what we didn't.
Do we have a slide from that subcommittee on what is included by administrative agency procedure? What is the scope of practice?
We exclude.
I would have to find that. We don't have a slide prepared for it.
Okay.
But I can look for that information.
But it's administrative agency proceedings in income maintenance types of admin agency proceedings. And recall that in those hearings themselves, non-attorneys are already allowed to advocate. So this recommendation by the working group authorized the provision of legal advice to prepare for those hearings.
And
I'm
I
sorry,
believe
but
that workers'
hold
comp
on.
was excluded early on. It's specifically excluded.
Yes, workers' comp is out.
Okay,
So
but can we take one section at a time and focus on family, children, and custody and try to get that done before moving into employment and income maintenance? Steve Fleischman?
Yeah, my question for Steve Hamilton and the judicial officers, are you individually and collectively comfortable with the number of units? Because it seems low to me, but you're the subject matter experts, not me.
And I'm going to turn to Judge Wiley. Are you back?
I am.
Okay. And are you good with this?
I am.
Because I mean, keep in mind, Judge Wiley's head of family and so has been doing this for quite a while. I had experience in family. It's a little bit dated at this point. I'm certainly comfortable with it if anyone cares. I don't know that anyone cares.
I do.
How about our other judicial officers who have experience with family?
Well, and I do want to explain that Stephen Hamilton, this is his area of expertise and practice. And we have spent an extreme amount of time on this, and this is what he, has recommended. And I think, unless I'm misspeaking, Stephen, this is what you were comfortable with.
Correct. I mean, the qualifier I would add is we developed these hours and units before the group as a whole voted for in-court representation. But I didn't want to go back and alter the recommendations I'd made because, as the group is aware, I am not in favor of the in-court representation. But for purposes of our discussion, I still stand behind these as being in conjunction with the 1,000 experience hours, 500 will have to be in family law. This would be adequate.
And there's also the general requirements that were touched upon earlier as well.
This is Judge Rubin. I think this is adequate. I mean, I don't think more would be bad, but this is, I think, adequate.
In that case, I move that we adopt these.
Second.
Okay, so that was Stephen Fleischman moving and Monica Wiley second.
Okay. Shall you take the vote?
Yes.
Bashan,
Yes.
Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No, because it's not enough due to the court.
Sarouche,
Yes.
Spyro,
Yes.
Torres Ambriz,
Yes.
Judge Wiley,
Yes.
and Judge Yu.
Yes. Thanks again, Liz.
The motion carries.
Okay, so now if you wish to continue your discussion regarding, if there's anything further regarding employment and income maintenance. And Leah, does there need to be a clarification in the practice area title? Because you were discussing the administrative agency procedures really having to do with income maintenance. So just, I don't know if there was, I know I cut you off. So if there was something more you wanted to say about that.
No, I don't think so. It's clear in the actual recommendation describing the practice area. I think this is an abbreviation for the purpose of fitting in this table.
Carolyn here. I just don't see, it's really something that's very confusing. We did exclude workers' comp. I found the two, there's three resolutions, one from 2020. Then on April 19th, 2021, we said wage and hour proceedings, DLSE. I may have voted for that. Unemployment insurance proceedings, EDD, and then all proceedings relating to public benefits. So maybe this is accurate, but it's, then we've got also wage and hour judgments for DLSE. That's kind of duplicative, but no, I think you need to make sure it's coherent and consistent. But it's, again, I'm troubled by the fact that it says all proceedings related to public benefits. So at a minimum, I think you need to refer to the actual
the proceeding types. I think that's good feedback, Carolyn, and perhaps Linda, you can make a note, because I don't think in the current iteration of the practice area section of the report, we list out all of the hearing types, and there is a chart that reflects them, the proceeding types. So we can add that. Maybe it was in there and I didn't see it.
However, I'm gonna be a fly in the ointment again, because I don't think this is enough. Sorry. I'm sorry, everybody. Everybody does hard work. I'm trying to be consistent to my values.
Well, I want to say one thing, and that is, even in our paralegal program, we have a class in public benefits, and it's actually a clinic. So even at that stage, if students are interested, they can already get started learning about public benefits representation. So I just want you to know that this may not be the one and only time that some of our candidates have contact with this kind of substantive law.
No, that's great. I mean, if you could tie the experiential hours, the 1,000 to 500, that would be a great thing.
Well, at this point, I don't feel inclined to amend anything.
I understand.
Stephen, did you wish to say something?
Yeah,
Fleischman?
I was on the subcommittee. The areas that we voted on are very limited in nature. Some of them, as someone pointed out, are areas where non-lawyers can already practice. I'm comfortable with this, and I move that we adopt the recommendation.
And is there a second? Ira?
I'll second it.
Yeah, second.
Thank you,
Ira
Ira.
raised his actual hand. So Linda, moved by Stephen Fleischman, seconded by Ira. And then whenever you're ready and have a chance to pull up your sheet, please take a vote.
I am ready. Bashan,
Yes.
Reynoldson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarouche,
Yes.
Spiro,
Yes.
Torres Ambriz,
Yes.
Judge Wiley,
Yes.
Judge Yu.
May I ask for clarification? Are we doing employment and income maintenance?
Yes.
Sorry, every now and then the dog justice comes and begs to be let out. So that's what I was doing. And I will withdraw the motion because I had previously made a motion, and I will vote yes on this motion.
Thank you.
So
Okay.
now should we go to landlord tenant?
It's the next here on our list.
Any discussion?
Yes.
Stephen?
It seems to me unlawful detainer and family are going to be the heart and core of this program. And I think housing, particularly when you start getting into rent control and mobile home parks and things we already voted on, are, I'm not going to say they're as complicated as family, but they can be close. And in disclosure, I don't practice in either one of them much anymore. So take that for what it's worth. I don't know. 11 just seems low to me relative to family. I would make it the same or even higher.
Amos?
Yeah, I agree with that. Again, the Housing Subcommittee itself didn't have a chance to discuss this as a committee. I think there are other things that could be on this list, but I'm sure it's not intended to be a totally exclusive list of what should be in the training, but things like settlement and sealing, and it can be very complicated and a lot of important rights at stake. So I would also increase it to be equivalent to family.
So if we put it at 12 plus 1, that would get it to 13. Stephen, Hamilton, and Claudia, what do you think of that, since we've already deliberated on this topic? Ira, do you want to speak first?
Not necessarily, but I'm talking. So, all right, I agree. It should be more, and I think it should be even more than 13. There's a lot in those subjects we're looking at right now. Really a lot. 15, 16 is my opinion.
I would support that.
Yeah, for me, there's never enough education. This is just the minimum. So we can always have more, but we should absolutely not have any less than what we already have discussed.
And remember, if the subject matter experts, which I am not in housing, decide that in order to include the various topics that we have considered would be within the scope of employment of this paraprofessional, you know, this is just a minimum. And if you just, I don't know, Stephen Hamilton, help.
I'm trying to be mindful of the comments. I think I'm intuitively having an issue with housing taking more educational units than family law as a basic premise. And I felt really confident as, you know, a subject matter expert in family law that we came up with a reasonable minimum to be applied in that area of law. And I'm wondering what would be the other areas in housing that would be included for 10 units, that the amount of time that would take, that's 15, 45, that's 450 hours of in-class and out-of-class instruction. Adding another 5 units would add
well, and let's not
a couple hundred hours to it. I guess that's the issue that I'm having. And we're doing this without knowing how the schools are going to create a program that would include the number of units that are being suggested.
Well, that's the other thing we have to remember. This is an addition to the experiential. And I think a lot of this is going to be learned on the job. But that's what I think.
And we have in the requirements that you have to, I know for family law we did it. Did we include, or is it part of the general rules that the experiential has to include half within an improved area, right? So someone's going to have to do 500 experiential hours in housing to get the license.
Stephen, I wanted to say, I know other hands are up, but one thing, and just to keep re-emphasizing that subject matter experts will be engaged. These are articulated as minimum educational requirements, and they can be increased. But to your concern, you could also propose that the family law always retain its status as being as having the maximum unit requirement. So if housing is ratcheted up, say at some point after the subject matter experts weigh in, that family law would similarly go up. You know, that could be sort of a position that this group takes that would afford for flexibility going forward, but keeping that policy position in place.
Steve?
Yeah, I move that we change housing to a total of 13 units with a best favored nation provision for family law, that it always have the top number of hours or equivalent to another group. No one goes above family.
Amos?
Yeah, I agree. I agree on increasing housing to the same as family law. I don't know about the most favored nation. I think I don't know about that, but I think they should be. I think we should be recommending equivalent education requirements for these two practice areas at this time.
Claudia, what do you think?
Equal is fine. I still stand by the minimum that we set is a good minimum. And I understand that it can always be increased once the subject matter experts have their say.
I am fine with increasing it to 13 as long as Claudia, Stephen, and Judge Harper's not here, as long as they agree.
I agree.
I'm okay with that.
So thank you for your friendly amendment, Amos. It is now included. Steve, do you want to make a new motion?
I move to approve.
I'll second the motion.
Are we ready for a vote?
Yep.
Okay. Rashawn?
Yes.
Nelson?
Yes.
Falmouth?
Yes.
Fleischman?
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson, Judge Rubin,
Yes.
Shining,
No.
Sarush,
Yes.
Spyro,
Yes.
Torres Ambriz,
Yes.
Judge Wiley,
Yes.
Judge Yu.
Yes.
The motion carries.
Thanks, Linda.
Thanks, Linda.
Do we have any others on this, or is that it?
That's it for
Okay.
education
So-
requirements.
Yes, thank you. So then I believe we're moving into regulation and discipline. Is that correct?
Yes.
And who is leading that
I believe
discussion?
I'm up first. Hi, everybody. This is Brady. I'm trying to screen share. Can everybody see the memorandum?
Yes.
Okay. 1 second. So this memorandum reflects some issues identified mainly by my colleague in the Office of General Counsel, Carissa Anderson, who's on the call with us. And essentially, we looked at a number of disciplinary provisions that have been enacted for attorneys in the name of public protection and raised to the Regulation and Discipline Subcommittees whether those should be applied with or without modification to paraprofessionals. This memorandum outlines 9 different issues. Of those, 8 are what the Regulation and Discipline Subcommittees reached unanimous recommendations on. And so I'm going to proceed through those 8 unanimous non-controversial issues first, and then return to the 9th issue, which was awarding costs where there was a difference of opinion within the subcommittees. To begin with, we created draft disciplinary standards for paraprofessional misconduct. That's attached as exhibit attachment A to the memorandum. And my colleague Carissa is the one who worked on these, but essentially these track very closely the standards for attorneys, and they recommend levels of discipline for various violations of the rules of paraprofessional conduct, which have already been adopted by the working group. Almost entirely, they track the attorney standards, but we did include a new provision to address practice of law by paraprofessionals outside of the scope permitted by their paraprofessional license. In that case, the presumed sanction would be license revocation or actual suspension, which is a serious disciplinary recommendation. The next item that these Regulation and Discipline Subcommittees considered was whether to recommend adoption of a paraprofessional equivalent to Business and Professions Code section 6086.13, which allows as a remedy when discipline is imposed, monetary sanctions. For attorneys, sanction can be imposed not to exceed $5,000 for each violation, subject to a total limit of $50,000. As a deterrent to misconduct and to protect the public, the Regulation and Discipline Subcommittees recommended that those same sanctions be available as a penalty for paraprofessional misconduct. The cost assessments and awards, as I mentioned, I will return to after we go over the unanimous recommendations. The next area in which the subcommittees made a recommendation was conviction proceedings. For attorneys pursuant to Business and Professions Code 6101 and 6102, there are special proceedings available for attorneys in state bar court who have been convicted of a felony or misdemeanor involving moral turpitude. Section 6101 allows, after a final conviction of a crime involving moral turpitude, a summary disbarment proceeding, so it's a quicker way to reach disbarment. And section 6102 allows for suspension of an attorney once they're convicted of such a crime until the time for appeal has elapsed. To promote public protection, and for the same reasons these proceedings are available for attorneys, the subcommittees unanimously recommended that this working group recommend that the same procedures be applied to paraprofessionals. The next issue covered by the subcommittees was the subsequent arrest notification provision, and that's Business and Professions Code section 6054. Under that provision, attorney applicants to the bar are required to submit fingerprints for the purpose of determining whether they have a criminal record, and such fingerprints are retained and used to provide the state bar with subsequent arrest notifications for all licensed attorneys. That's a process by which, from the State Department of Justice, the state bar receives notification when attorneys are arrested. For the same reason that same public protection reasons that law is applicable to attorneys, the subcommittees unanimously recommended that they be applied to paraprofessionals as well. The next topic covered was involuntary inactive enrollment. The attorney provision is Business and Professions Code 6007, under which attorneys are subject to involuntary inactive enrollment under certain circumstances, including when they undergo involuntary treatment pursuant to specified provisions of the Welfare and Institutions Code, where the attorney has asserted a claim of insanity or mental incompetence in any pending action. Obviously, if they're making a legal claim that they are insane, they shouldn't be practicing at that time. Or where a court has assumed jurisdiction over the attorney's law practice, or where the attorney, due to mental infirmity, illness, or use of intoxicants, is unable to perform their duties competently, or is unable to practice law without threat of harm to the interests of clients or the public. Or whether when the attorney has caused or is causing substantial harm to clients or the public, and there is a reasonable probability that the state bar will prevail on merits in an underlying disciplinary matter. So, in other words, that final provision states that when there are disbarment proceedings going on, if the state bar can make a showing that there is substantial harm that is ongoing, then this provision allows the state bar court to enter an order of involuntary inactive enrollment, which prevents the attorney from continuing to practice and cause harm pending the eventual completion of the disciplinary proceedings. So for these same valid public protection reasons, the Regulation and Discipline Subcommittees unanimously recommended that the working group recommend adoption of provisions mirroring the involuntary inactive enrollment procedure for attorneys. The next topic that the subcommittees discussed was Business Professions Code 6049.1, which addresses misconduct in another jurisdiction. And that provides that if there's a final order of discipline entered in another U.S. jurisdiction, that is admissible as conclusive evidence that an attorney is culpable of misconduct in California. And there's a special proceeding in state bar court here, of course, for paraprofessionals. It would be before the paraprofessional board, but to determine the degree of discipline to impose based on that order of discipline in another jurisdiction, or whether the conduct does not warrant discipline in California under our rules, or whether the proceedings were for some reason unfair, and for that reason. But basically, it establishes that misconduct, a final order of discipline in one jurisdiction, can be evidence of and lead to discipline in California. While recognizing that there are very few licensed paraprofessionals in other jurisdictions, that may change, and to protect the public, the Regulation and Discipline Subcommittees recommend a mirror provision for paraprofessionals, so that if they are licensed somewhere else and subject to discipline, that can be the basis of discipline here in California. The second to last unanimous item was the rule of limitations. Pursuant to State Bar Rules of Procedure Rule 5.21, when attorney disciplinary proceedings are initiated based on a complainant coming forward with allegations of misconduct, the disciplinary proceedings must begin within 5 years from the date of alleged violation. There are a number of tolling provisions, including the pendency of the attorney's representation, so that the clock doesn't start to run until the representation is over, and also when the attorney is willfully trying to conceal his misconduct. The subcommittees considered this carefully, and they recommend that a similar 5-year statute be adopted for paraprofessionals. However, to increase the ability of complainants to have their claims heard, they recommend that a discovery rule be included in the rule of limitations, meaning that that the period for complainants to bring their complaint to the state bar only begins running either when they know of the misconduct or should have reasonably become aware of the misconduct. So unlike for attorneys, where the 5 years is told only if the attorney is actively trying to conceal their misconduct, here we have a slightly more liberal recommendation for a discovery rule to give complainants more chance to bring their complaints forward as soon as they are aware of them. The final issue on which the subcommittees reached unanimous recommendation is the second look. For claims against attorneys, we have State Bar Rule of Procedure 2603B, and that basically says that when the Office of Chief Trial Counsel closes a complaint from a member of the public without initiating disciplinary proceedings against an attorney, that complaint may request that the Office of General Counsel review the decision to close the complaint. And we have attorneys who, as part of their job, will review the complaint, review any investigation done by the Office of Chief Trial Counsel, and either affirm the decision to close the complaint or send the file back to the Office of Chief Trial Counsel with a recommendation that they reopen the complaint either for further investigation or to initiate disciplinary charges. And essentially, this provides complainants with another option for their complaints to be looked at to see if there's something there, grounds for investigation or discipline. And then after that step, of course, complainants may appeal to the Supreme Court for review of any closing decision. So those are the 8 issues that were found to be non-controversial, and a unanimous decision was reached. I think it probably makes sense to open it up for questions or discussions on those, and I will pull up the resolution on those 8 items now. And it might make sense to have a motion to approve these 8, and then we could have discussion on them.
So move.
Second.
Linda, did you get that?
Was it Judge Yu that seconded?
Yes, thanks.
Sorry.
Yes.
Yep, yes. Have that. Thank you.
Is there some way, is there some way to get the whole thing on one page?
Let's see.
I just don't know why. Yeah, because we have so much space above and below. I don't know if there's any way to make it fit the screen.
Maybe do it on landscape. Is that what you're doing, Brady? Oh, yeah.
So I can get.
I think I've got it.
Okay.
You want me to do that?
Yeah, I just think it's helpful for us to have up what people are voting on and discussing.
Do you see Steve's hand up, Brady?
Oh. Go ahead, Stephen.
Brady, I was just trying to move.
Oh.
So
Yeah,
can you see all of the resolutions now? It's kind of small.
Very
print.
small.
Right. I don't think that we can do.
You can't do side by side, like where you see 2 pages.
Sure, I can try to do that. Let's see. Does that
Yeah,
work?
make it a little bit, yeah, make it a little bit bigger and it'll still fit. Okay, you have,
I think that's as big as I can go and have
Okay.
it be a 2K.
that's fine. So was there discussion about this? We have a motion on the table.
You know, I think that if it helps to think, all of these are areas in which we've based very closely, if not completely mirroring these recommendations on the procedures for attorneys.
Okay, well, I don't see any requests for further discussion. So Linda, I think you can take the vote.
Okay. Bashan,
Yes.
Bernelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson, Judge Rubin,
Yes.
Shining,
Yes.
Sarush,
Yes.
Spiro,
Yes.
Torres Ambriz,
Yes.
Judge Wiley,
Yes.
Judge Yu.
Yes, thank you, Linda.
The motion carries.
Great. And now I will return to, let me take screen back. The last item on this agenda item. And that is cost assessments and awards. For attorneys, Business and Professions Code, section 6086.10 allows or provides that disciplinary orders imposing public approval or greater level of discipline shall include a direction that the attorney shall pay costs, which include basically recoverable costs as they would in civil proceedings. Now, there has been litigation and some moves in other areas, other professional licensing regimes, to avoid chilling the right of licensed professionals to seek a hearing on disciplinary charges, to cut off the costs at the date of hearing. That's what's done under the Department of Consumer Affairs for various licensing programs there, pursuant to California Business and Professions Code 125.3. I know the State Bar, I believe, is looking at making a modification to its own rule for attorneys, and it's likely that a court would hold that due process requires some such limitation. And in fact, and Ira mentioned this or brought this up after we circulated this memo, that due process does require that whoever is imposing the discipline have discretion not to award costs. And any resolution that we pass would, of course, lead to implementation, recognizing those due process concerns, and imposition of costs would not be required. The Paraprofessional Board or the Supreme Court opposing discipline would always have discretion not to, if justice required. So currently we have two resolutions, and I will bring those up, two competing resolutions, page 6. The first resolution offered by the subcommittees was that the California Paraprofessional Program Working Group recommends that paraprofessionals against whom discipline is imposed be subject to an assessment of costs to be limited to costs incurred before the date of the disciplinary hearing. So that last phrase there is consistent with what licensing programs under the DCA do and with due process to avoid chilling paraprofessionals' right to seek a hearing. An alternative proposed by one member of the subcommittees was a further resolution that the California Paraprofessional Program Working Group recommends that paraprofessionals against whom discipline is imposed be subject to an assessment of costs to be limited to costs incurred before the disciplinary hearing, with costs further limited to costs of investigation and excluding costs of hearing preparation. So under that alternative, rather than having a date certain of the date of the hearing after which costs could not be recovered, to limit cost recovery to the date of the hearing plus the state bar would not be able to recoup costs incurred before the hearing if those costs were not for investigation, but rather for hearing preparation. So I think that Amos and Ira might have some further thoughts on these two alternate resolutions.
Oh yeah, I do. I was in support. I guess I still am, but not obviously not positive of the alternate resolution. Well, I think that awarding the costs of the prosecution or regulation, whatever it is, preparing for the hearing as opposed to investigation, I think it has a pretty strong chilling effect. But I forget, Gianna, somebody brought up the fact that there's a Cal Supreme Court case on this, and Brady just mentioned it, and it's called Zuckerman. And after the meeting, I looked at it more carefully, and I think it undermines my argument about limiting the cost assessment to only investigation, because it considered due process implications, chilling effect implications, and it didn't make that limitation, but it did set out what I believe, and the dissent believes, are requirements that the governmental authority has to use in exercising its discretion in imposing the costs. And it's a paragraph long. And if anybody wants me to read it or have somebody put it on the screen, I hope that can be done. But I think that ought to be in our rule, because it's a due process requirement articulated by the state Supreme Court.
Ira, let me ask, rather than putting the whole decision, which is a very long paragraph, if your concern might be assuaged, if we went with the first resolution, but made clear that the hearing panel and/or court would have discretion not to award costs consistent with due process requirements.
Well, I think it ought to say has discretion, and somehow we make a reference to the Zuckerman case, has discretion as set out in Zuckerman versus Board of Chiropractic, and cite the case.
So I have the resolution up on my screen in Word. If you want me to share that and we can work on changing the language, would you like me to do that?
Sure, that'd be great.
So
can I make the suggestion? Would that be all right?
Yes.
So rather than the alternative, let's work with the beginning. Put a comma after disciplinary hearing. With the hearing panel or court imposing discipline required to exercise discretion as to whether to award costs or as to 2, the amount of cost to award. Consistent with due process principles set forth in Zuckerman v. State Board of Chiropractic Examiners, comma, 29 Cal 4th.
Hold on a second.
Sorry. Comma, 29 Cal 4th, 32. Uh, 2002.
Is there a comma after that or?
Comma 38-41. And then parentheses 2002. So I think that maybe that merges the concerns of both, and I will open it again to discussion.
I think that, sorry, I think that the place in Zuckerman I was referring to is at page 45.
How about 38 to 45? But, you know, I think there's 2 ways to go on this. Of course, in implementation, we will not write any rules that violate due process, but including this clause could indicate to those reviewing the report and recommendations that this has been taken into consideration. Kimberly?
I'd just like to move to accept this resolution.
Second.
Ready to
I
vote?
don't think there's any further discussion, so let's vote.
Okay, Bashan,
Yes.
Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson, Judge Rubin,
Yes.
Shining, Carolyn,
Yes.
Sarush,
Yes.
Spyro,
Yes.
Torres Ambriz,
Yes.
Judge Wiley,
Yes.
Judge Yu.
Yes, thanks. Linda.
Motion carries.
Thank you.
Was there anything further, Brady?
No, not on this item.
Thanks very much. Okay, so let's see here. The disclosure of criminal convictions. Leanne?
Linda, did you guys discuss who's going to talk about this?
You know, we didn't, but
I got it, Linda. I'm okay.
great.
All right.
Thank you.
So as all of you know, we have met and we've made decisions on the disclosure of information that's going to be provided for all of the different licensees as action is taken against them. But one thing we didn't is on criminal charges and convictions. So in your packet, you had a memo from us. And what we're looking at is really just mirroring what happens for attorneys when convictions, first of all, when a conviction is charged, and then also what happens to them once those charges come forward. So in our discussions, you can see there, and I don't know, Linda, if you can share the screen just so they can see what it would look like.
Sure, hang on a second.
Okay, it's in the packet. But for felony charges, what would happen is when it happens, it would be posted as a consumer alert on the licensee's web page on their information, on their profile, and it would show that this has been charged. They've been charged with a felony. Of course, this is for felony charges. The profile would list the information that you see there in the red box with the disclaimer for the individual. And then once they actually have been convicted of a crime, what we wanted to do is the same thing that happens as attorneys, and the information would be transmitted to the state bar court. And it would also be posted on their licensee's record, showing that it had been transmitted to the state bar court. So this is just really mirroring what happens with attorneys, and that we would basically like to request that this public disclosure be the same. So we have two resolutions there that we would like to be voting on, and I think that is it, unless there's any questions. So the two resolutions, one is posting the information, and the other one is agreement that the information would be sent to the state bar court.
I think it's not the state bar court, because the state bar court is not going to be involved in discipline for paraprofessional. It's to the oversight.
Oh, sorry, you're right. Yes, to the committee. So
Right, any questions? Yeah, any questions or discussion about this? Anyone wish to make a motion?
Move to adopt.
Second.
Amos, was that you second?
Yes.
Okay, Linda, whenever you're ready.
Okay, Sean,
Yes.
Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
I'm going to abstain, so I missed the conversation. I'm so sorry.
No worries, Nicole.
Judge Rubin,
Yes.
Shining,
Yes.
Sarouche,
Yes.
Spiro,
Yes.
Torres Ambriz, Judge Wiley,
Yes.
and Judge Yu.
Yes. Thanks, Linda. We're keeping you busy today.
The motion carries.
And I believe the next and final topic under regulation and discipline is the unauthorized practice of law.
Yes, thank you. So the next item we have is the one with probably the most discussion we might have on the unauthorized practice of law. So basically unlicensed activity by individuals. And as all of you know, and you've been part of hearing all of the discussions, this is a concern by a lot of individuals that by having this new license type, this professional, that will open it up to more potential. We've heard a lot. We obviously, this is up and running, but just the potential for a lot of unauthorized practice of law by individuals outside that aren't licensed as whatever we call them, the paraprofessionals. And so what we did is we looked at this. We had a lot of discussions. We've had a lot of individuals come and talk to us at our different subcommittees. And most recently in December, we had individuals come forward from the Los Angeles District Attorney's Office and also from OCTC to talk about kind of some of the issues that they run into, some of the problems that they face as they're prosecuting these cases. And as you know, the state bar does not take these cases forward. They do transfer them over. They can take some actions, but for the most part, they get transferred over to the LA DA's office for prosecution. So with that information, and really just thank Amos a lot for his hard work on this and putting this together, we actually put a resolution together that we really want to put forward, talking about the need to have resources and the authority to take action against these individuals. And so our first resolution, the first resolve is just kind of the intent information that we have. and that we want to make sure that we have the resources and the ability to take action against these individuals. And then the third resolution, if you're looking at your packet going down, we really want to make sure that, first of all, that really there's changes to statutes and there's available remedies for these, including harsher criminal penalties and making felonies available even without priors, because right now it can just be a misdemeanor. And then the funding and resources for not only law enforcement to prosecute, but also for anybody in the process of looking at it. We also want to be able to give funding to State Bar and the OCTC, and also be able to do citation and fines, because this program is going to have a citation and fine program. We want to be able to cite for these type of activities. Just really extending the statute of limitations. You can see there the whole list. I'm not going to go through all of those. So that's our resolution, is that we basically make this a focus. And then the important part really is, before that even happens, to take action, that really we devote sufficient resources from State Bar to actually educate individuals on the difference from these individuals and their scope of practice and what they can do. So individuals will know to go forward and make sure that these individuals are licensed. And then the last resolution that we have is just to make sure that we have the laws, the statutes, basically allowing for us to be able to take the action that we need to. So Amos, I don't know if you have anything to add to that.
No, I appreciate that, and I agree with everything you said. I'll just underscore that we did hear serious concerns from law enforcement, from legal services, from consumer advocates, that this really is going to be a new form of fraud. In other words, holding yourself out as a licensed paraprofessional when you are not. And they've seen this. So they're not operating on a blank slate, just guessing it's going to happen. They've seen this happen in other contexts, and there's real concern. And it's already under-resourced. Enforcement of unauthorized practice of law and the inability to charge as a felony was really cited as a really large limitation. So I think both the discipline and the regulation subcommittee both independently heard about this and then had joint meetings about it. And I think the proposal is really to make sure that this risk is addressed if the State Bar rolls out this program.
So with that, we would just ask for a motion. And
so moved.
Second.
And so I believe that was Stephen Fleischman who moved and Sharon was second. Is that correct?
Yes.
All right, thank you. Carolyn, your hand's raised, and then Brady.
Sure. How much in additional increased resources is going to cost?
We don't have a fiscal estimate, but what are you referring to? Additional resources for prosecution, the Office of the Chief Trial Counsel?
Right. Yeah, it's the third resolution says new laws and increased resources are needed. Additional funding, victim fund.
Yeah. So we had put together a proposal maybe 3 years ago that would be a general fund funded as opposed to State Bar licensing funded initiative through a consortium of district attorneys' offices to enhance UPL prosecution. There was a dollar amount on that, which I can't recall right now. The majority of funding, the funding that's being described here, would come from the state's general fund as opposed to attorney licensing fees. But certainly this is something that, or paraprofessional licensing fees, but this is something that we could cost out.
Could we attach as an exhibit to this?
Sure, yes.
And one other thing I did want to add that Amos brought up, and I know that just with our work with DCA also, is there is ability to work with other entities as well in this process and grants that they can get and things that, you know, for unlicensed practice where it can go into other worlds of workers' comp and IRS and other things as well. So there might be other resources that can be tapped into it.
I think Brady had his hand up, but I have a further comment maybe before he does. The first mention that I heard, and maybe again, I'm wrong, of the concept that a paraprofessional, to be named later, will be engaged in the practice of law was, I think, on July 26th. I mean, I know we talked about it. I know ATIL's talked about it. It's, you know, it's statutory. It's in the ABA model rule. It's, I think, 1.0 something or other. I'm still not comfortable with that. And I love all these things. Again, we've got, you know, an hour, I guess, to discuss them. But I just, you know, it seems like a clever fix to a very complicated problem that will require overruling or discussion of several cases. And I just would prefer that we have and consider some other term rather than the unlicensed practice of paraprofessional licensing. It's a little bit more of a mouthful. But again, I think you're going to confuse attorneys who are reviewing this in the public comment period, that somehow you're creating mini lawyers who will practice law. So I know that's not what we're intending. I know this is a new kind of licensee, but I think it's a hot button thing to say unlicensed practice of law and just sort of throw it in there as if that was the way we wanted to do it all along. I can talk more about that. I'm interested. Ira's got his hand up. Brady's got his hand up.
Yeah, Brady has had his hand up for a while, so I think the order is Brady, then Ira, then Julia. And Brady, you're muted.
I wanted to clarify whether what's up for vote includes that we've got resolved and further resolves and then a final resolved on the second page, which I believe was an alternative proposed by one commissioner. And the concern I would raise is that on the one hand, it's one thing to say that in connection with the implementation that the State Bar proposed legislation necessary, that in the next week before the report is finalized, to propose actual legislation that would award resources to law enforcement related to the unauthorized practice of law. I just don't see how that can be done in a thoughtful and complete way in the next week when we haven't looked at that issue.
I agree. We are not resourced to do that in the next week.
So I would recommend that the first four resolutions be considered separately.
Ira?
I think I've understood all along for more than a year, more like a year and a half, and I thought everybody did, that exactly what we are doing is creating a quote mini lawyer or something like that, but a new category of people who are practicing law. Now, if that's not the case, I'd sure like to hear somebody, in addition to Carolyn, say so, but that's what we're doing. And also saying so alerts the public that that's what's happening. And analytically, it is what's happening. Okay.
Julia?
Yeah, I've been under the same impression. I mean, it's pretty clear when you teach paralegals that they cannot engage in the unauthorized practice of law, that includes providing direct recommendations regarding the selection of forms, regarding any strategy. They're precluded from doing all of those things, so that the door we are opening up, and I mean, Greg can speak to this as the expert, that this is the practice of law in a limited scope. If it is within one of the activities this licensee has been certified to do, they will be providing advice, counsel, representation, and all of those things that would normally go as the unauthorized practice of law. So that is why, for example, the difference in being a paralegal is that you can only work under the supervision of an attorney. LDAs, they can fill out forms, but they cannot counsel clients. So
right. And yeah, and just to jump in, I mean, we have used the phrase practice of law, and I think it's what you're saying, Julia, in regards to, is it like an attorney who, once they get their license, can practice in any area unfettered, or is it these delineated scopes? And unless, finish your comment, but then I'd love to hear from Kim on this point.
yeah, no, I'm done, and I'd love to hear from Kim or Greg or anybody, but if I didn't describe it correctly, please correct me, Kim.
So I think there's two things where we might be getting confused, and I think that's why Amos may have his hand up too, because what we're talking about are individuals who are actually practicing the scope of what a paraprofessional would do without a license. And so that world of those individuals are what we're talking about. Then there would also be a potential for individuals who are a paraprofessional who are going to be practicing outside of their scope. And we covered that in our standards to make sure that we can take action against them that way, because then they would have a license, and we take action against their license. And I guess they could also be prosecuted for practicing law as well. But Greg or Amos, correct me if I'm wrong in all of that.
So let me try to clarify two pieces. So I agree, Kim, with what you're saying. Just to try to avoid the confusion, when these resolutions are targeted at the unlicensed practice of law by people who are not licensed to practice law. That means they're not attorneys and they're not licensed paraprofessionals. So this is not changing any laws with respect to who can practice and what they can practice. This is to provide additional resources to law enforcement to go after, to investigate and prosecute unlicensed practice of law by non-licensees, so non-attorneys and non-licensed paraprofessionals. I think it's a separate question that Carolyn's raising about just the whole program. And I agree with the people who are talking about, we're clearly proposing a limited license to practice law. In certain practice areas doing certain tasks. It is the practice of law because it is advising clients, representing clients, appearing in court, choosing forms. So I don't think there's any doubt that it's practice of law. But that's not what these resolutions are about. These are about people who are not licensed either as an attorney or as a paraprofessional. The other thing I wanted to clarify was Brady's comment. So if there's something that we can do in the last proposed resolution, I think the reason this came up as described in the memo was that there was some confusion when we discussed changes to statutes and available remedies to stand up the program. We feel strongly, the two subcommittees feel strongly that in standing up the program, these changes should be made because this is the public protection part. the regulation of unauthorized practice of law, increasing resources is necessary and important in standing up the program. And it wasn't clear, I think, I think as you've heard, there's some time limitations and resource limitations about how and when this will be proposed. I think I would be comfortable changing it to just making it clear that any required statutory changes or additional resources should be included in implementation of the program. This isn't separate and to be thought about later, but this is being proposed as part of implementation of a paraprofessional program, that there be these changes in law and additional resources for public protection.
Okay, so Amos, I think you clarified my misunderstanding because I didn't. So this is when it says non-licensees, it means the scope of the world of people who are not licensed to practice law, except maybe a clarification somewhere in the memo itself can say what we mean is everybody but lawyers. Or perhaps, you see what I'm saying? Non-licensees now blurs. So a non-licensee includes paralegal, but not a paraprofessional. You see my confusion? I get what you're saying completely. I just want to make sure this is understandable. Make sure
A non-licensee is someone not licensed by the state bar.
And that's how it's identified in the statute that defines
Okay.
an authorized practice of law.
Okay. And then Greg or Amos or Fariba, maybe you know, I do in the back of my mind now recall was there a rule that we put in that was a new rule regarding the definition of the unlicensed practice of law in the regulations? Maybe that's my misunderstanding.
You mean in the disciplinary portion?
Right.
I'm not rules of professional conduct. That
It would be
discussion?
it would be in the rules of paraprofessional conduct.
Yeah.
Was it there?
The practice of law is not defined under rules currently, and it's not part of the proposals to do so through the paraprofessional rules of conduct, professional conduct, because that is just, the court has already, the Second Rules Revision Commission considered whether or not they wanted to memorialize the holding in Bierbauer in rule, and decided not to because of the difficult cases that you've referred to in the past, Carolyn, where I think everything that we're envisioning that the paraprofessionals would be licensed to do, prepare forms, make filings, argue on behalf of clients, provide legal advice, clearly falls within the definition of the practice of law. And absent a license from the state bar approved by the court, they would be engaging in UPL. But the court has been reticent to have a black letter definition because there are those difficult cases where it is where you have to untangle the types of services that people are providing, and so in some instances it may cross the line into the practice of law, and other areas it may not. So there is no definition in our current rules defining the practice of law, which is consistent with the rules for attorneys.
Okay, so I get it, and I would just maybe suggest a sentence in here that could be thrown in at some point in time. I don't know if this is a final memo, but explaining what Leah said with regard to that statutory definition. I don't know. Maybe it's a fly, a little gnat. Anyway, I'm done talking.
Carolyn, to your statement, I think, and putting what Leah said together, the first resolution there, it says that this has heard the increases in the unauthorized practice of law and fraud by non-licensees, because a licensee is now going to be either an attorney or a paraprofessional, because they're both a licensee of the state bar.
Or one of the attorneys who did not pass the bar but got the 2-year COVID approval.
Right.
That is correct.
Okay, so that makes sense. Is there someone who would like to move? And I guess, Brady, were we talking about the first 4 here?
Well, yeah, with Amos, Linda made a change to the last resolution consistent with Amos's comments. So I think our practicability concern has been addressed.
I will move, Mrs. Fariba.
And I'll second that, and that is for all 5 of these paragraphs,
Right.
correct?
Right. Yes.
Thank you.
Okay, so I think, Linda, you can take the vote.
I'm sorry, who was the second on that now?
Julia.
Okay, so it was Fariba who made the motion. Is that right?
That is correct.
Okay. Right. Bashan,
Yes.
Brynelson,
Yes.
Thelma,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartson,
Yes.
Kirkmeyer, McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
Yes.
Sarouche,
Yes.
Spyro,
Yes.
Torres Ambriz.
Claudia notified us that they had to step out.
Okay, Judge Wiley
Yes.
and Judge Yu.
Yes, thank you.
Okay,
The motion carries.
so let's take just a very brief, 5 minutes or so stretch break. It's 2:27. Let's resume it at 2:35 and just take a little head clearing break. Okay, thank you.
Thank you.
So
We are recording again.
thank you very much, Linda.
So Linda, do you want to go ahead and put up the memo? So the recommendations you're being asked to consider today regarding program evaluation metrics do come from staff. As outlined in the report, they reflect a series of activities, including a discussion that the working group held in December of last year, designed to identify key risks or concerns or goals of the paraprofessional program. And if you could scroll up a little bit, Linda, to the section of the report that outlines those broad goals.
Okay, let me pull that up. I didn't actually have the whole report ready.
Oh, sorry. Okay.
I can bring that up.
So these are goals around closing the justice gap and protecting consumers. Sort of the broad dual goals. And so we had done as a group some brainstorming about the data points that would need to be collected in order to determine whether or not those goals were in fact being achieved. In addition, we have heard on several occasions about the Washington State program. And as you all know, there is some debate as to the reason for the ultimate decision to sunset that program. But one thing that is clear is that the licensing requirements were such that there were a very limited number of individuals that were willing or able to be licensed. And so program viability is also a key consideration in our proposed evaluation metrics. So here you can see in the report the goals that you all had identified last December and the delineation of those goals that were then translated into data collection points. If you go down now to the table that Linda put together, so we took that information as well as the input that we got at our June meeting from the National Center for State Courts, as well as the professors at the University of Utah who are doing an evaluation of that state's paraprofessional program, to come up with the recommendations that you see here. Outlined in an appendix, I believe it's Appendix B, is the full list of potential evaluation metrics, and you can see some analysis as to whether or not those particular data points were recommended. Several were not because we do not consider it feasible to collect that data. And in general, as the report outlines, there has been an approach or an underlying premise that we should try to align ourselves with the recommended model being promulgated by the National Center so that it will enable for cross-state comparisons of programs, which I think is really important. The only thing I'll highlight before I see your hand up, Steve, is that we did receive a rather lengthy public comment on this item yesterday, I believe. It is my opinion that many of the data points that the public commenters seek to be included are in fact included in this design. There may be some confusion around the terminology of survey, a suggestion that the data would be voluntarily submitted on the part of the paraprofessional. That is not the intent. And of course, we cannot require clients to submit data to us. The one, I think, substantive question for the working group has to do with looking at case outcomes. That is something that we have limited to satisfaction outcomes rather than actual substantive or procedural outcomes in a case. In the National Center model, they are looking at recommending that an analysis of case outcomes be done, specifically comparing paraprofessional performance to self-represented litigant performance. We have also had some discussion around comparing case outcomes between paraprofessional performance and attorney performance. There are a number of challenges associated with being able to actually effectuate that kind of research design. And so it is not currently being recommended. With that, I'll turn to questions. Steve.
Thank you, Leah. As it relates to program viability, I understand the need to study that going forward. My question relates to today. Do we have any sense of A, how many people we think are going to sign up to be paraprofessionals, and B, how much the program is going to cost to get it up and running, say for the first 5 years, to give it time to get legs, so to speak? Because the reason I'm asking is in Washington, it costs the state bar $1.4 million after 5 years, and they pulled the plug.
Right.
So I'm just, do we have that data now?
So the data that we do have, and this data was used to select the pilot counties or the phased in implementation counties, you might recall. So you have the data on folks who have sat for the bar but not passed the bar. And we looked at that data going back 10 years. And we also have some limited data on the number of ABA school certified paralegals in certain counties in the state. And so that's a population, those are two populations that we feel are likely candidates to apply for participation in this program. We attempted to collect data on the number of registered LDAs in each county from the County Clerks Association, and we were unable to do so. But I am optimistic that through Elizabeth and her organization, that we will have some reach out into that community. So the numbers of potential licensees are in the many thousands in California, even just in our pilot counties. So that's what we have in terms of the potential licensee population. In terms of cost, I did draft something prior to coming back into the executive director role for the interim executive director. And I think we're very clear that absent very specific legislative support, we would not seek to use state bar general fund money to support the initial implementation cost. Perhaps via a loan, that might be one way to do it, but the first avenue that is going to be sought is grant funding. And I have begun preliminary conversations in that vein. So I think $1 million to operate over the first couple of years of the pilot or the phased in implementation period is not unreasonable. And I do expect to seek philanthropic money to support that effort.
Okay, but just for my knowledge, I guess, you're not taking money from, say, enforcement to run the program in the beginning?
No, absolutely not.
Okay, and in terms of the first question, the potential universe, I think I heard you say, is 4 digits.
Yes, absolutely. And we can include that data if it's not already in there in the report that goes to the board, the specific numbers of potential licensees as we've identified that universe.
Right.
Yeah.
So if you were going to Vegas and the over under was 1,000 paraprofessionals in a year, how do you bet?
I'm not a gambler, so I don't know what over under means, but what I would say is I would expect that we would have over 1,000 paraprofessionals after maybe 2 or 3 administrations of the exam. And I'm thinking the exam would be administered twice a year.
Okay, so at bar dues of $500, if you get 1,000 people in, that's a budget of $500,000 in terms of revenue. Is that enough to run the program going forward?
Well, I would think so. It depends as the program. I think we looked at data out of Ontario that gave us some idea of complaint rates. I think we expected to get 5.4 complaints out of every 1,000 licensees. So as the program scales, your need to increase staffing scales, right? But you also experience economies of scale. So I can't quite answer that program, but I think $500,000 a year, certainly while the program is of modest size, should be sufficient.
But we're also, I mean, we're creating oversight boards, we're creating disciplinary boards. You're going to have to run the exam. I mean, it seems to me a lot to get this program up and running. And I'm glad to hear it's not coming from the State Bar general funds.
Right. I think, you see one of the evaluation metrics is stable and sufficient regulatory funding source. And I think it's an important point. It's not going to be viable if it has to be subsidized by the State Bar General Fund. And when I talk about the General Fund, I'm referring to the funding that's used for attorney discipline and regulation. That would make it not viable in my view.
All right, thank you.
Carolyn?
Okay. Loan. What do you mean by loan?
Well, I understand, and I think I may have learned this from Kim, that in the DCA world, and Kim, correct me if I'm wrong, that to start a new board, sometimes there are loans from the general fund to support that initiative, but those loans are repaid. And so since that's a model that's out there in the professional licensing world, I thought that it might be one that we could consider applying to this situation. And Kim, is that accurate?
Yeah, there's different ways depending on how it gets through, but it can either be a loan from the general fund. Sometimes it's even like a loan from State Bar that would go to this, and they would have to repay it for once the program gets up and running. It could be a loan from another area, but yeah, that model is out there.
Could you give some examples of where that's worked in the past?
Yeah, we've had different ones. We've actually had a board that has come in that has borrowed from general fund and then had to pay that money back once they got up and running. And then we've had another entity under one of our boards where it was kind of like a licensure group under that one, but their funds were separate. And in that perspective, the board that housed that licensing program, they took money from their fund and loaned it to this program, and then that program had to loan that back. I mean, had to pay it back.
Which entities?
So it's been with the medical board has had that happen, and I believe with the other one, I think was under bar. So I'd have to get more information on that, Carolyn, to give you specific examples.
I think you may have mentioned osteopathy to me, Kim.
Oh, osteopathy. When they first came in under a general fund, when they became maybe a program under them.
And then grant funding, or no, I'm sorry, philanthropic donations. I saw that in one of those old bar budgets. What is that, and where would that be? And are there constraints for conflicts of interest?
I'm not sure I fully understand your question. The bar has fairly consistently received philanthropic money over the years to support specific initiatives, many over in the admissions side and also in the access to legal services side of the bar's house. So there are different philanthropies. There's also an organization called Access Lex that is not, I'm not quite sure what its legal structure is, but it certainly does grant making in these kinds of spaces. So there are a number of different options. We would be subject to conflict of interest provisions as we generally are.
So nobody who would actually do a sandbox regulation adaptation with a paraprofessional, you wouldn't ask them for a philanthropic grant, right? Or would they be able to grant to the state bar? How would that work?
I'm not sure what you're referring to. And recall, the sandbox proposal is a year out from even being finalized. But if you mean, would we take money from a Facebook philanthropy? Maybe you're referring to that. I don't know, Carolyn. I haven't. Those certainly is not the kind of philanthropic organization that the bar typically works with, and not what I have in mind. No. Sharon?
I was just going to say that I think that case outcomes data is really, really important. We are looking at testing our assumptions on access to justice. And I think it has to go beyond client satisfaction, because sometimes you don't, as a client, you don't know what a quote unquote like regular outcome is in a case, and you may be happy, but there may be something else that a typical attorney in that situation would have done. So I think it's important to test across the board, to test against self-represented folks as well as represented folks. I understand that some of that may be cumbersome, but legal aid organizations have to, I've done it for years, report on case outcomes. And it's just something that you gather. Like, I also think that we want to look across the board at the outcomes that are coming from this, so that if there are good outcomes, that's something that we can, that's like a feather in our cap. So why wouldn't we want to go beyond satisfaction levels for this data?
Well, I certainly agree. It would be great to have the data. I would just suggest that the legal services required reporting has to do with the fact that the State Bar is granting funding to these organizations, and the reporting is pursuant to an MOU. The reporting for the paraprofessional could be and will be a requirement of licensure. But we do not have similar reporting requirements, and we don't have the authority to impose them on self-represented litigants or on private attorneys. So our ability to do any kind of comparative analyses will be quite limited. And so for that reason, I have just frankly struggled to figure out how it is that we would analyze case outcomes in a vacuum. Because we're sort of judging them against what. So I see a couple more hands up, Steve, and then Carolyn, or I don't know, Sharon, if you have an idea as to how to get around that.
I was just going to maybe Sharon, but there was the public service folks did send a letter saying that there are a lot of things that they already have to report that are not in the metrics here. And is that true? And why don't we just use what the IOLTA legal services people have to report? Or include that? Is it included?
Well, we went through that letter fairly carefully, and I think many of the elements that the letter indicated should be collected are in fact reflected in this table. As I mentioned in my opening remarks, I think maybe they were thrown off by the term survey, and maybe it could be written more clearly to reflect the fact that it will be mandatory, the mandatory reporting for the paraprofessional. But in terms of the IOLTA, reporting requirements, I am not an expert on them. I do know, as Sharon mentioned, case outcomes are required. I had always understood that it was at an aggregate level that we were not able to link a specific case to a specific outcome, but I could be wrong in terms of the data that we get. So that, I don't have anything more to add there. Steve?
Yeah, this is really just a suggestion, but if we can work it into this report somehow, I think it would help the program viability if we included in there what you said a few minutes ago, that the plan is not to rely on State Bar general funds, and therefore this program will not cause a drain on existing State Bar functions, including enforcement.
I agree with you.
Yeah, I agree as well.
We'll do that.
How, okay, I'm not sure what we're going to be voting on this, but where do we put that in? Does it go in here? Does it go in the final report? Both?
I think this resolution as drafted is simply asking you to approve the recommended metrics. I don't know. I can tell you today that we can make sure to include it in the report. But I don't know. We haven't actually asked you all for a vote on that, and I don't know that we can do that today.
You just read my mind, because I was going to ask Justice Petro if we need to vote on something today so that it can be in the report.
Leah?
Well, we can include it in the report. I can give you my word. I don't know how exactly we can vote on that today because it's not on the agenda. Perhaps we can say that further resolved that one of the metrics will specifically address the need to not use any enforcement or, somehow bootstrap it into this agenda item, then we can add it as an additional resolution.
Look, I don't want to take more time than necessary. If it's going to be in the report that we see in a few weeks, we can deal with it then. If you don't feel we need a vote on it now, we can move on. But given what's going on in the world, I think that would be I strongly encourage that.
No, I agree with you. And it's not going to be a few weeks. You're going to see the report in a few days.
Okay.
Yeah. Sharon?
I just wanted to respond to what you were saying about, additional ideas for how to collect case outcomes in a helpful way. I think that just having the paraprofessionals be mandated to report back in a similar fashion as IOLTA funded programs do, I think that's really important. I don't think it's too cumbersome. And I think that data could be compared. There's like plenty of data out there that could be extrapolated as comparison points. There are Shriver programs out there that do similar things in certain areas. That data can be compared against that. But just having the self-reported data is in of itself a start. And I think it's going in the right direction. My other question has to do with the affordability factor. Are we comparing hourly rates to what attorneys in those counties are charging and doing a comparison of that?
I think the challenge with that is that how do we gather data about what attorneys are charging?
There's no way to survey a handful of
Linda,
attorneys?
you guys put together a 69-page report. You guys did a magnificent job gathering that data.
It was not a data about what private attorneys were charging for specific types of cases. And the problem with doing a survey is that you're relying on, people who choose to respond to the survey, and that might really skew the information. So it could be that only attorneys who charge very low rates respond to that survey, and attorneys who are charging very high rates don't respond to the survey. And so the question is the reliability of survey data that's used for comparative purposes.
I do work on attorney fee motions, and there are all sorts of publicly available reports on hourly rates.
That's exactly what I was going to say. There are companies like Mercer. This is what they do for a living.
Well, I don't know. The data that we've been able to get on hourly rates, the private data comes from Clio, and that's statewide data. It's not broken down by county, and it reflects those who use the Clio accounting or the law office management system. So there is not if we are going to mandate paraprofessionals to provide their fees, which we are, we don't have a parallel provision in place to mandate attorneys to report their fees to the state bar. So it is not comparable data or information. We can certainly compare what we receive to the averages that are out there from these other data sources, but it's not scientific or rigorous. It doesn't allow for a rigorous comparison.
I would just, I have faith in this group and in the state bar to be creative. And as someone who really opposed, I was in favor of fee caps, and, we were the minority. I think it's really important to look at that data, to find a creative way to look at that data, whether it's, and my guess is that attorneys may choose to report this.
Did you pull the stuff out of the Konica for Jody?
I did. It's on our report.
Okay.
I think you're behind.
Stephen, can you mute yourself?
Yeah, sorry about that.
Okay. Anybody else have comments? I don't know, Justice Petrie, you see there is a hand raised in the attendees box.
Yeah, we can quickly see, and again, it's got to be a 2-minute limit. Linda, if you could allow Charlie Gillig to speak.
Hi, I'll be very brief. I was the principal author of the letter that you received. I wanted to say first, thank you to Leah for explaining the definition of survey. I was under the impression that that meant voluntary surveys from paraprofessionals. I just wanted to speak really quickly to that question you just asked about tying outcomes to specific cases. We do that in legal service reporting. I can tell you that we submitted the EAF homeless report last week, and it is a very detailed report tying multiple outcomes and level of service to individual matters. And so I do think that if that data was collected, you could match level of service and outcome to the fees for individual cases to help to identify whether there is, there are issues with affordability. So I could say a lot more. I'm going to leave it at that. I just wanted to make that point about the way the data is currently collected for legal service agencies.
Thank you for that, and thank you for the letter. Fariba?
So in the proactive regulation memo, you may have read that I put forth a suggestion about a survey, linked to a survey that clients, paraprofessionals would complete after they receive the service. And these types of questions could also be included in that survey. Now, whether people will actually take the time to answer those questions, whether they will answer them accurately, that's all left to be seen. But they are the source of this information. And you don't ask, you don't get. So that could be another use for that survey.
And maybe I would be willing to add here a further resolved that the working group, I don't know what, recommends or directs or suggest that staff review case outcome reporting required of state bar funded legal services organizations and incorporate similar reporting requirements for paraprofessionals as part of the evaluation effort. I mean, I'd like be willing to certainly look at that, and to the extent it makes sense, incorporate that in. It just, to be clear, doesn't allow for comparative analysis. Any other comments?
Does that capture it?
I think so. Maybe we want to say state bar funded legal service program instead of IOLTA, because I think there are now a number of
right. Yeah, that's what I was wondering about. I think that's true.
Yeah.
I don't think you need a dash.
All right, so I don't see any more hands up. I'm looking for a motion and a second.
Move to adopt these 4 resolutions.
Do we have a second? So that was Ira. Thank you. Do we have a second?
Second.
Okay.
Linda, can you take the roll?
Yes, just a moment. I'm having some technical difficulties here. So that was Ira who moved.
Yeah.
And Stephen Fleischman who seconded.
Yes.
Okay. Bashan.
Yes.
Donaldson.
Yes.
Thelma.
Yes.
Fleischman.
Yes.
Hamilton.
Yes.
Hartston.
No.
Kirkmeyer.
Yes.
McRae.
Yes.
Olvera.
Yes.
Robinson.
Yes.
Judge Rubin. Shining.
Yes.
Sarouche.
Yes.
Spiro.
Yes.
Torres Ambris. Judge Wiley.
Yeah.
Judge Yu.
Yes.
The motion carries.
All right. Thank you. And then we're going into proactive regulation. Fariba, were you going to lead us on that one?
I was? Okay.
Well, I don't know. I could have gotten
I
it
think
wrong.
Leah was maybe, yeah.
No, I was not. I was hoping you or Amos would do this one.
Hot potato.
Or Kim, I missed some of those meetings, so I'm not sure if Kim was.
Amos, you want to do the honors? You're always so prepared.
Sure. Okay. So proactive regulation. So this is something that the Regulation Subcommittee looked at. Proactive regulation is risk-based regulation. So the idea is separate from having a rule, it's something that's proactive in trying to identify risks and be responsive to those risks. So we had to first identify what risks we might want to regulate through proactive regulation. We identified 3. One was excessive or unreasonable fees, but since the working group voted not to regulate that, we didn't do any further work on that. Another was unlicensed practice of law, an increase in that. And you just heard we separately addressed that with other recommendations. So the main one that we focused on for proactive regulation was competency and the risk of incompetent legal services. So we talked to experts and we looked at what other jurisdictions did in terms of proactive regulation. It's still somewhat new, but there are examples of things that we looked at. And I'm just looking at our memo now. It included MCLE, toolkits, self-assessments, ethics hotline, online resources, case file review, client surveys. What we decided on was to focus on the supportive resources and not overburden paraprofessionals with a lot of mandatory proactive regulation, especially in light of the evaluation that is expected and the burden of data collection that is expected in terms of evaluation, which we think is essential. So we focused on and are going to recommend, it's on the screen, that we adopt proactive regulation measures that are supportive and not burdensome, including continuing legal educations and toolkits. One that was discussed at length was a interactive self-assessment and whether that should be mandatory or voluntary. And we are recommending that it be voluntary, but that could be a very useful tool. Ethics hotline, online resources, and annual reporting requirements. Now, technically these annual reporting requirements are not proactive regulation, but we did think it made sense for the bar to be reaching out to paraprofessionals to ask them what further support they would recommend for competent legal services. So that's something that could be done annually, just getting that information. And as mentioned, collecting information about fees charged. Because we're not regulating fees, we thought it important to collect that information. So that is our recommendation. It looks like there's an alternate resolution. I think this is what Fariba mentioned. Fariba suggested the addition of the next to last bullet point. I can
explain that if I may. Didn't mean to interrupt, Amos. So what I'm proposing here is just another layer of consumer protection. This is a new program, we're launching it, and I'm recommending that we just launch it the right way. I think that it's a huge burden to expect that the state bar is going to continuously monitor attorneys, monitor paraprofessionals, unless somebody complains and it comes on their radar. This being a new license program, this being involving a field that unfortunately is riddled with a lot of bad actors. They're not all bad actors, but I'm just saying is, there's LDAs and there's these other independent paralegals and form preparers that basically start working, and there's absolutely no regulation. And even the LDAs, I don't think there's any active monitoring and oversight of that program either. So I'm recommending that the only thing that's mandated as a rule is that the paraprofessionals provide a link to the survey and a little blurb informing their clients that they have the option of using this link to give feedback as a way of maintaining quality of this program at the state bar level. I want to clarify that there is really not too much burden on the state bar, at least the idea that I'm proposing, outside of coming up, purchasing this program or having their people design one. I'm not sure if that people on staff, but smarter, more high-tech people than me. But it is something that is basically automatically sort of keeping this data and would automatically alert state bar staff that, you know, paraprofessional license number 1, 2, 3, 4, 5, 6 had now received, you know, 10 surveys or whatever, 90% are negative. And this is not disciplinary in nature. It's just a way to provide resources and information to underperforming paraprofessionals who, you know, have gone through licensing, through education, through, you know, all that work, and now are performing in a way where 90% of the people who happen to answer the survey about them give a thumbs down or had comments and what have you. So as far as, so I'm addressing Kim and Amos's comments, that is the only mandatory part of it is providing a link. That's it. Paraprofessionals do that, they have met their burden. Whether the customer, their client uses it or not, that's not up to them. All they do is just provide the link. In terms of creating confusion, listen, as someone who's been dealing with signage as part of their job and tackling the problem of people not reading signs, and we use Transcend or 5th grade level, we use colors, line, whatever. People don't read signs. They knock on the door under the sign that says closed. Are you really closed? So I'm just saying it is not our responsibility to make sure people read the material we provide. We could make the language clear, but we're not responsible for any further than that. On the opposite side, just balancing that, we are providing a way for people to give us feedback. And again, as I mentioned before, we could collect all kinds of information as long as people are willing to give it. We could even go one step further and allow them the option, user the option of providing their name, their case number, their issue, their outcome. I mean, we can collect all kinds of things. And again, this is not high maintenance for the bar staff. They could go, you know, look at the program every day to see what people posted, or just wait to be alerted about some paraprofessional who's gotten many negative comments. And again, it is not disciplinary in nature. I'm just suggesting as a way, but first of all, to provide resources and information and additional training to reach out to those paraprofessionals, and then to collect some data that we need, again, for on the chance that these people, these consumers will take the time to actually provide us with that information. Let me just make sure I've covered. And this will not be like Yelp or anything, so it's not going to be available for the public to use in terms of choosing which paraprofessional that they're going to hire. It's just, again, for purposes of State Bar collecting data and providing resources and additional training to those paraprofessionals who may need it. Thank you. Any questions for me? Sharon, you go first. I'm sorry, Amos wants to make a comment, sorry.
Yeah, just to be clear, at least in the Regulation Subcommittee, which is 3 of us, myself and Kim did not agree with this, and happy to talk about why. But I think mainly I don't think it would provide a meaningful consumer protection, and may lead to confusion, because this would not be the same as filing a disciplinary complaint, would not start discipline proceedings, would not be available to the public. So I think it would be of limited utility and might, again, create the false impression that filing a negative review on this survey would lead to some sort of disciplinary action, which it would not.
Yeah, and I want to acknowledge both of those points and just repeat that, number one, we can make it really clear in this program that this is not, does not start a complaint procedure, and to start a complaint, click on this link, and somebody would have to check that I've read, understand this before they can go forward. And also, if you don't ask, you don't get. I mean, in my opinion, it's not a good reason not to put this out there for those consumers who would use it, just because some consumers may get confused. You can make the language as clear as a bell, but still people may not read it, may not understand it. So I just think on the balance, it's really valuable resource for information for us, for the State Bar, and a valuable resource for consumers who wouldn't complain, but wouldn't mind giving feedback. Kim, do you have a comment on that before I ask Sharon and then Ira?
No, I just had the same concerns that Amos had. He just raised about the fact that them knowing whether they're submitting a complaint or whether it's just this other feedback. And I think we weren't opposed to them actually being able to send out and get a survey. It was just the mandate that they have to attach it. I think that's was at least my concern.
And on the mandate piece, I did want to make one comment, is that I think it makes a difference that the paraprofessional knows that the clients now have this information, rather than they don't know what to do if they don't like the paraprofessional's performance. So I think for those paraprofessionals who may be bad actors, even after going through all the rigmarole to get licensed, I think this will provide an additional layer of consumer protection for a lot, just not that much trouble. Sharon. You're on mute.
I got like 2 sentences out on mute. Sorry about that. I had some of the same concerns as Kim and Amos, just about the limited utility and also confusing consumers. The other thing is, like, I'm thinking of the Yelp scenario where you have a lot of business owners that actually have their friends, or they do their own Yelp review to kind of like pump it up. So like if we did do this, there would have to be some kind of validity measure that these were actually coming from actual clients.
I think you're absolutely correct. Again, I don't think there's any foolproof way. That's why this is not going to lead into any kind of discipline. It's just a way to provide more resources. And the other important piece of it could be that the state bar could get data that otherwise they wouldn't get. And it comes from the mandate that the paraprofessional provide the link, provide this information that the consumer would not otherwise get on their own. Ira, sorry.
2 points. As we're talking, it occurred to me that this link client survey, it might turn into this might be good, might be bad. When you take your car in, the person who meets says, "Oh, please fill out, please go online and give an evaluation of how I did for you." And the paraprofessionals might do that. And then, of course, they also say, "Please give me the highest rating, if you will." All right. The other point is where it says online resources, the third bullet point in each of these two. Can we get some examples of what that is? Half our lives are online now or something like that. So examples.
Are you remembering what we meant by online resources? Were they just educational materials and?
Yeah, toolkits.
Yeah, toolkits and things like that. Yeah.
Even the self-assessment, I believe, is an online resource.
Yeah, and I will add, I think Kim already mentioned this, both Kim and I thought client satisfaction surveys are a great tool. We certainly could make that a tool available online and encourage people to use it. The question is, should it be mandated and should the results be non-public and go to the bar?
Any other comments or questions? Okay. So the first resolution is without the survey link, mandating the survey link. The second one is. So don't give it to me because I'm going to put the first one forward first.
Okay, I will move for that the first resolution on the screen be adopted.
Second.
Any further discussion?
I think we should clarify if we vote for if the first one passes, the second could also pass too, right? Or no, not right.
The first one doesn't include the mandate to provide the link to the survey that I am suggesting.
Yeah, and also it's different in the last bullet point. See, it's got 2 instead of 3.
There you go.
And it's phrased differently too. Oh.
That was just a clerical error on my part.
So I think the one that was there before was the correct one. Or at least that's the one that was discussed and approved, I believe, by the subcommittee.
That's correct.
So my motion is for the first resolved there. On this
I guess what I think we ought to be all clear on is if this first one passes, can we also move for the second one or the additional item?
I can tell you, I will not make that motion. So somebody else might.
All right.
So I think we're ready for a vote on the first resolution.
Okay, and that was, Dana, you seconded this?
Yes, I did.
Okay.
Just a quick question. Sorry, this is Sharon before we vote. Is there room to discuss other forms of surveying clients? Or would that be encompassed in evaluation? Because I think that, you know, the intent of it is good. I just don't like, I don't agree with how it's going to be carried out and the potential confusion.
So I will respond what the discussion was of the regulation subcommittee. I think evaluation is different, and evaluation certainly can and I think should include reaching out to consumers, and that would be separate. So this is regulation by the bar. The evaluation, I think, would be by a third party and certainly would include some surveying or reaching out to consumers, is my understanding.
Yeah. And one part of the other discussion was the challenge of how do you reach out to consumers, these consumers. You know, the best source would be through their paraprofessional, right? When the paraprofessional is in contact with them to part with this information.
To address Sharon's, though, we could actually put that in the toolkit like Amos was stating, and we could amend the motion to say and include an example. I mean, this would put it on State Bar, but include an example of a customer satisfaction survey in the toolkit.
I'd be in favor of that.
Yeah, and that is something we discussed in terms of the toolkit and online resources. So we can specify that if people prefer.
And I would, on the chance that this passes, which with 2 members of the subcommittee and our consumer protection guru not liking my idea of consumer protection survey, I would hope that we do add at least a voluntary sort of way to provide a link to a survey or some sort of a consumer satisfaction survey form or something like that.
Okay, I think we're ready to vote.
So is this, did you want to have this language that I just added, the sample client surveys?
Oh, thank you. Yes, that works for me.
I accept it as well.
Okay. So I will take the vote. Bashan,
Yes.
Reynoldson,
Yes.
Falmouth,
Yes.
Fleischman.
Yes.
I've been advised that Stephen Hamilton had to leave the meeting. Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Oh, yes.
Shining,
Yes.
Sarouche,
No.
Spyro,
Yes.
Torres Ambriz, Wiley, Judge Wiley,
Yes.
Judge Yu.
Yes, thanks, Linda.
Thank you. The motion carries.
Okay, terrific.
So Justice Petra, I'm wondering
Yes.
if should move the governance item before.
Yeah, I think we should.
Okay, let's try to do that quickly, Linda.
Yes, I will. Hold on a second. Sorry. So, as I detailed in my memo, I initially brought a recommendation for a paraprofessional licensing and oversight committee to the working group in December. I received some feedback and brought a revised recommendation in June, and received further feedback, and then and I'm not going into a lot of detail because it's in the memo and I want to be sure we have time to get to the last item. We developed a final recommendation or a third recommendation based on the feedback from the June meeting, met with the Regulation Subcommittee, who offered some tweaks to that. And so now we have the last recommendations for both the governance structure and the governance functions. And I can share that with you. And what you'll see in terms of the first table, the composition and appointing authority, the items with the asterisks were changes that were made based on feedback provided by both the working group and the Regulation Subcommittee. And so what we're looking at now is having a judge appointed by the Supreme Court, 2 attorneys appointed by the Board of Trustees, 3 paraprofessionals appointed by a professional organization, and with the suggestion that until there is a sufficient body of licensed paraprofessionals in California, that potentially the professional organization be either CALDA or the California Alliance of Paralegal Associations, and that they consider appointing paraprofessionals that are licensed in other states until we have people licensed in California, at which point the recommendation is that they come from the different regions of the state. And then a total of 6 public members, non-licensees, so neither lawyers nor licensed paraprofessionals, and 1 paraprofessional educator. And with the suggestion is that the appointing authority for the paraprofessional educator alternate between the Board of Community Colleges and the law schools that have paraprofessional programs. Are there any questions on this?
And we've talked about this, so I think we're probably ready to move forward, but if anyone has any comments or questions.
I just have one question. Under the public members where it says non-licensee, does that include lawyers?
No, so it's non-licensees of the state bar. So there are 2 attorneys that would be appointed by the board, but there would be 6 total that are not licensed at all by the state bar.
Perfect, thank you.
Thanks for clarifying that.
And I don't know if we want to vote on this separately or if I can review the governance functions, and if there's not a lot of discussion about.
Well, I just had a question on the appointing authority for the paraprofessionals. I think before it had been like the Board of Trustees, and I'm just wondering the thought process in having like it looks like an outside professional organization appoint these individuals. Just a question.
So, yeah, I think the idea was that they be appointed by, once there is a sufficient number of paraprofessionals that they'd formed their own organization, that they would appoint members from there. But until we have that, so when the board is first, when there's the licensing committee is first appointed before anyone's been licensed, that's where those the appointments would come from.
Julie?
These are board members who theoretically are going to be sitting in on disciplinary actions. I'm not aware of any other boards, including boards within the Department of Consumer Affairs, Kim, correct me if I'm wrong, where board members are actually appointed by private professional organizations. Board appointments are generally made by the governor and the legislature, and in this case, the court, but not by a private organization. Am I wrong, Kim?
No, that's correct. That's why I question it. This, I think, is the first time I've seen this. With this.
Yeah, I would not favor that
So you're referring to the non-lawyer professional organization and also the educators? Or just the
I'm
Calder?
mostly referring to the appointment of the 3 paraprofessionals by private organizations. I guess to the extent that you're allowing law schools who have paraprofessional programs to appoint the paraprofessional educator, that might present a similar problem. There just has to be some accountability generally to a public official.
I think the Board of Trustees is actually a better, because they could get applications from individuals and
I agree.
they could appoint.
Yeah.
Yeah. Farida, did you have your hand up?
Yeah, just quickly, I also have a question. Last time I had suggested that the board consider that one of the attorneys be from a court self-help family law facilitator program. And is footnote 1 to this table supposed to address that, which says appointing authorities should be encouraged to consider diversity of practice areas in their appointments?
Yes, and I think that's what the regulation subcommittee ultimately, based on your feedback, didn't want to require that it include someone who is a self-help center attorney, but that should be a consideration.
Or really any field, just in general, diversity should be considered.
Yeah. Ira?
Yeah. On appointing the 3 paraprofessionals, I'm wondering if instead of board of trustees, it could be possibly somebody or a group in the Department of Consumer Affairs. I don't know if that's a good idea or bad, but we kind of defaulted to the board of trustees. I don't know if there's a good reason for that. I'd just like to hear anybody, like particularly Kimberly and Julianne.
I mean, in my opinion, they're the ones who are kind of tasked with consumer protection. I mean, they're potentially over this entire program. I'm struggling with who would be any other appointing authority. I don't think us, but yeah.
Let me recommend, because I think it's an oversight on our part altogether. The Supreme Court should not just have one appointment. So I would recommend, that we just consider replacing for the paraprofessionals. We could make that from the Supreme Court. We could also do the paraprofessional educators from the Supreme Court. Unless Greg, you have another suggestion, but I do think that was just an oversight on our part.
Can I reply to that, Leah? The reason I was my eyebrows got raised on having the board of trustees make the appointment of 3 paraprofessionals is because it's kind of a lawyer group, although it's not. It's minority. I don't know. There's a lot of lawyers on it, but the Supreme Court, it's all lawyers, right? So my preference would be the trustees over the Supreme Court.
Or it could be split. If there's 3 paraprofessionals, there could be 2 by the Supreme Court and 1 by the board, or 2 by the board and 1 by the Supreme Court.
Yeah.
Julia?
We have Greg, since we're talking about the Supreme Court, we do have Greg's hand up.
Oh, sorry. Go ahead, Greg.
Fine. Yeah, no, I had a similar question about the balance of appointing authority between the court, the legislature, and the governor. It might be worthwhile to try to explore a balance that's similar to how the Board of Trustees appointment authority is distributed among those branches of government. I tend to agree with Julianne also about having private entities appointing in this manner. Ira, I hear you. I know that most members of the court are lawyers. I think they all are. They don't think of themselves as active market participants in that way, and they think of themselves a little bit more than just being lawyers. So that's the only comment I would make on that.
Okay, Julia?
Yeah, I wanted to point out that I think it is a good idea to make the paraprofessionals not appointed by private groups. And the Supreme Court is good, but it could also be, as Greg suggested, or Leah said, a split between the Supreme Court and the Board of Trustees. I just think that it already, it's, you know, when you look at the paraprofessional educators going to go in between community colleges and alternate with the California law schools, I mean, these are massive entities that to come down to one candidate amongst all of them, I think that rotation may have to be considered further, just because, I mean, we have, I think it's 14 paralegal programs in community college. Let's just say that all of them end up having some form of this program. I mean, that's going to require that the community colleges, so maybe it's going to have to be the Board of Governors of community colleges. I mean, I don't know how we specify this, but to think that you're going to have all California law schools agree on one candidate, I find that very unlikely. That's just my take on this.
Just let me add that they're almost all of them are private.
So should this one be from the Board of Trustees?
Linda, I think because we have to move on, I like Greg's suggestion. So we have 13 members of the board, 5 appointed by the Supreme Court, 4 by the governor, and then 2 each by the Assembly and the Senate. If this working group is amenable, I would suggest we do a similar proportional distribution, and then we can do that not sort of in a working draft on this call on this during this meeting, but the resolution can say that the proportions will reflect that same structure as the board appointment authority. Is there agreement to go with that approach, just so we can move on?
Can I, sorry, my hand has been up. I just wanted to.
Sorry, I didn't.
Oh, that's okay. I just wanted to contemplate whether it should be 1 judge or more, 2. As you all know, I was the only judge on this until we had Justice Petru as chair, and then other judges came in. I worry that if it's just 1 judge, that voice might be too strong or too much, because people may defer to the bench officer, and sometimes it's good to have a different point of view. And so, you know, I mean, because there may be, you may want to have a judge from a larger jurisdiction and then a judge from a smaller jurisdiction. The court will be working with the paraprofessionals and may want to have some word in terms of this discipline process.
Can I respond briefly? Because this was the regulation subcommittee asked to comment on this, and we had similar views. The problem is the number. The state bar staff and board, I think, was recommending a 7-person committee, and we had strong views that we needed more. So we were talking about expansion. We also thought it should be an odd number. And so the question is, who would we remove? It would be instead of who, because I think we also wanted to have a majority public members, non-licensees. So it was a difficult decision, but I think if we include another judge, we'll probably have to, you know, change other aspects of this. And so we'd have to really figure out how to do that. This was sort of a compromise. I do think I would like to see us include language that there are important reasons to divert from the 7-person board or committee, that there seems to be some momentum behind at the board and staff. And I think this was really thoughtful that we went back to the original proposal of 13. So Judge Yu, I would suggest if we had a judge, I think you need to make a recommendation of how that would affect the other members of the committee.
Okay, so I only wanted us to think about it, and I truly really appreciate the explanation and the transparency. Amos, thank you so much. I support your saying that in the future, you know, or maybe for consideration, expanding to 13.
Sorry, this is 13, so we'd have to expand it further.
Oh, so leaving it at 13. Yeah, that's pretty big.
Could a oh, my hand is not up, sorry. But could a non-licensee include the judge since they're not technically not licensed by the state bar?
I think technically you're right. As far as, you know, we're not active members of the bar, but I certainly don't think that this contemplates any of the public members being a sitting judicial officer. Whether that could potentially include a retired judicial officer, I don't know.
Yeah, I just want to support Judge Yu's comments with regards to judges from different counties.
Right.
They will add different points of view. Yeah.
And not having the judge voice be overridingly strong, but having the counterbalance.
So is someone moving this? But we don't have who is appointing the paraprofessional educator. That's not filled in currently.
Well, I had a suggestion that we not do that approach and just say that the
Right.
appointing authority will mirror that of the board appointing authority. If we're going to leave it at one judge for right now, then that is the resolution I would recommend.
Okay, so where is that resolution?
You'd have to strike reflecting the composition in the following table. Or maybe you could have member type, reflecting the member type in the following table, but not the appointing authority. Yeah, and get rid of that appointing authority column.
Okay, so it says resolve that the California Paraprofessional Program Working Group recommends that the program's licensing and oversight committee include 13 members, reflecting the member type in the following table, with the appointing authority to mirror that of the State Bar Board of Trustees. Okay, that makes sense. Is someone making that motion?
So moved.
I'll
Second.
Who was the second?
Steve Fleischman was. He beat me.
Okay. You ready to take a vote?
Yes.
Okay. Bashan,
Yes.
Renelson,
Yes.
Thelma,
Yes.
Fleischman,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarouche,
Yes.
Spiro,
Yes.
Torres Ambriz, Judge Wiley,
Yes.
Judge Yu.
Yes, thanks,
Motion
Linda.
carries.
And I am going to warn people that unfortunately, I think I'm going to be asking whoever can to stay a little bit longer today because I just don't see how we're getting done by 4. Julie, did you have your hand up right now to say something?
Yeah, we don't have the number 2 next to paraprofessional educators to equal the 13. So that needs to go into the grid. We have 2.
No, I think we only have one. That makes it
Yeah.
13.
2, 4, 6.
No, it's 11.
It's
No.
one judge as well.
Oh,
Yeah, it's 13.
okay, sorry.
It's okay.
So,
Okay.
and I don't know if I need to go into detail on the governance functions. It pretty much reflects.
scroll down?
what was- I'm sorry. Is someone saying something? Oh,
Yeah, I asked if you could scroll down so we could look at what you're discussing.
yes. So I'm just, yeah. So this is the governance functions, and this reflects pretty much what was presented
Linda, we
before.
can't-
Oh, I'm sorry. I can't see that on my screen. I'm still seeing the
Oh,
prior.
I'm
resolution.
sorry. I'm sorry. I thought I had changed what I was sharing. There we go. Now can you see it?
Yes.
Yeah.
Okay, apologize. So this reflects pretty much what was shown at the last meeting.
Right.
We made some changes, actually just one changed based on the input from the Regulations Subcommittee, having to do with in the discipline section, that the hearing panel selection, rather than being recommended by the Oversight Committee and approved by the Board of Trustees, that hearing panel selection would be made by the Oversight Committee. And other than
And
that.
did I hear you? Yeah, so did I hear you correctly that that's the only change from what we've looked at previously?
Yes, it is.
Okay.
So does anyone have any questions about that? I know it's a very quick review. Kim.
I'm sorry to bring this up now, and I must have missed it before. I just have a question on the exam development. It shows that the committee is going to be developing the exam and approving the questions and all of that part. Is that accurate? That's just kind of unusual to me, and so I just wanted to ask.
That's a good question.
Usually it's like
you're in the right, yeah.
And I think the idea is that they would approve, tell me if I'm wrong, Leah, but I thought we were going to engage an outside examination.
Yes, it's there.
But the final approval of whatever they develop would be with the Oversight Committee.
That's also unusual. Usually, for at least for us, we don't want our board members involved in like knowing the questions and seeing the questions and all of that. So it may be that they get to approve the contract to do this outside. I just don't know if they should be approving the exam. Just and maybe just because it might take a longer conversation, maybe this is something I can give you information from our OPES unit, Leah, later, but.
Yeah.
How does it, so Leah, how does it work with the state bar, the bar exam?
Linda, this is where you took this from, correct?
I took this from, so with the state bar, there's the Committee of Bar Examiners.
Right.
That's very involved, and we didn't contemplate having a separate outside
Yeah, I think the problem is though the Committee of
examiner.
Bar Examiners have particular kinds of background. I mean,
No, they don't.
again-
They don't. But I think that this problem has been raised before. So I think to move this along, we should probably put TBD here, because I think it probably does need to be changed. But in the interest of time, maybe we just can't do that right now. And maybe the resolution says that this is something that's going to have to be resolved. That the working group recommends that this is developed in a way that is consistent with best practices, which may not be exactly how it's being done now.
Yeah.
Yeah.
That makes more sense to me. So Kimberly, thanks for raising that.
Sorry, I didn't catch it earlier.
No. Is there any other discussion? And is there a resolution on this? Leah or Linda, do we have?
I'm typing it. I'm sorry.
Oh, sorry. I thought there was one. Sorry.
I'm amending it based on the discussion we just had. Sorry, I can bring that up as I'm drafting it, so. So I've changed it to say that it reflects the governance functions reflected in the table from the August 31 staff memo, with the exception that functions related to exam development will be developed
Leah, you had, I think, some suggested language there. And you're muted right now.
functions related to exam development will be identified by, I don't know how else to do it. It could be the Oversight Committee, State Bar staff at a later date as consistent with best practices and the working group's discussion on 8/31/2021, something like that.
State Committee. Does that work?
You're gonna want to put the year since we've been meeting in
Yes.
2020.
Okay, is someone moving this?
I will move approval. It's Dana.
Thank you,
I'll
Dana.
second it.
And Julia, the second, thank you. Linda, whenever you're ready.
Okay, oh, here we are. Okay, so I have. So tell me again, who moved and seconded?
Dana moved and Julia second.
Okay. Bashan,
Yes.
Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Sorry, yes.
Spiro,
Yes.
Curtis Ambreeze, Judge Wiley,
Yes.
Judge Yu.
Yes, thanks. Just
The motion
introducing
carries.
everyone. Thanks, Linda. I'm gonna have to leave at 4, just giving everyone a heads up. Sorry.
Yeah, we know you have more on your agenda, including duty starting at 5 again.
Sorry.
So thank you for attending all day in the midst of all of that. Let's keep rolling and see what we can get done here. The last thing on is the statutory and rule changes recommended for program implementation. Brady, I believe you were going to lead that discussion, or did I get that one wrong?
That's right, but I'm going to ask Brady, can we, and Justice Patrick, can we assume that members have read the item? And let's have Brady address any, I think there are a couple of provisions where there were different perspectives on approaches should be taken, and that only those be highlighted by Brady.
Well, yeah,
Sure.
Yeah, that makes sense.
So these were all discussed with the Regulation Committee, and there was a unanimity among staff and the Regulation Subcommittee on all but the item regarding the statute of limitations to be applied to claims against a paraprofessional for an act or omission arising from the performance of their duties. For attorneys, those types of claims are covered by a Code of Civil Procedure 340.6, which sort of provides a two-part statute of limitations for claims against attorneys. It's 1 year after the plaintiff discovers, or through the use of reasonable diligence should have discovered, the facts constituting the wrongful act, or 4 years from the date of the wrongful act or omission, whichever occurs first. So in other words, there's a pretty strong 4-year limit, even if the plaintiff has not discovered it. There is some tolling available, for instance, when the attorney is willfully concealing the facts constituting the wrongful act or omission. Now, the Regulation Subcommittee, in considering this, was in agreement that the legislature should be recommended to create a specific statute of limitations for claims against paraprofessionals, just as they do for claims against attorneys. This is necessary for clarity because in the absence of such a statute, just like there was for attorneys, the statute of limitations to apply would depend on how the claim was pled, whether it was pled as a breach of contract, a tort claim, and it could be anywhere from 2 to 4 years under those, pre-existing general statutes of limitations. The Regulations Subcommittee disagreed or did not reach unanimity on whether the statute of limitations for paraprofessionals should be exactly the same as for attorneys, or whether it should be somewhat longer. It was suggested that it could be 2 years from the time the wrongful act occurred or the plaintiff became aware of it, or a 4-year cap. Or it was also suggested, and this was the most client-friendly suggestion, that we recommend that the legislature basically impose the same statute as for attorneys, except they oppose a broad discovery rule tolling implementation. So in other words, until the client knew of the act or should have known of the wrongful act or omission, the tolling provision would, statute would not begin to run at all. So Linda, I think, do you have the separate page with the resolutions on this one? And maybe we can discuss and vote on this one first and then the others, or I can pull it up.
And meanwhile, I believe Stephen Fleischman has his hand raised.
Yeah, 340.6 was passed in the 1970s to address the legal malpractice insurance crisis. It's an incredibly powerful tool for attorneys. It's not simply the 1-year aspect of the statute. It's the way it's been interpreted by the Supreme Court. It's the way the tolling provisions work. It's the way the accrual provisions work. The issue, as I see it, is if we want to encourage paraprofessionals to buy malpractice insurance, then we want 340.6 to apply. On the other hand, if the goal is consumer protection, we don't want 340.6 to apply. So to me, those are the choices. At the end of the day, I'm in favor of applying 340.6 to paraprofessionals. And so, I disagree with the way this resolution is phrased. I think it should just be, we recommend that 340.6 apply to paraprofessionals or create a separate statute for it.
Brady,
Amos?
what do you think? Well, actually, I'm curious, Brady, what you think about that comment, and then we can turn to Amos.
I think that I can definitely see the merit in that comment, and some of the discussion had with the Regulations Subcommittee was that, the same rules should apply to lawyers and paraprofessionals. And then there was discussion as to whether, the 2-year, the 1-year, 4-year statute is to be applied to both, or whether those numbers should be tooled with. But
the 4-year in reality, the 4-year almost never applies.
Okay.
It's really a 1-year statute, and the question is when the 1 year applies.
Amos?
Yeah, so I like the way you framed that, Stephen, and I think that does reflect somewhat of the Regulation Subcommittee's discussion, and we are all here, so I think I don't want to speak for them, but I don't remember there being a big difference of opinion in the Regulation Subcommittee. I think we actually all agreed that there should be a similar statute for paraprofessionals. I think where we didn't reach a final conclusion is what the statute should be. I think there was strong opinion that it should be longer than 1 year. So, I recommended 2 years. I don't remember anyone disagreeing with that. So I actually don't think there was disagreement among the Regulation Subcommittee of doing something similar with just a 2-year instead of a 1 year. And I think that is really important, as Stephen mentions, for potential malpractice insurance and liability reasons, and certainty for paraprofessionals about, there being some end date. But I think we've already heard, part of the UPL discussion, and part of what we heard from other public commenters was there needed to be a longer statute of limitation. The one for attorneys was too short, and shorter than what a normal tort or contract statute of limitation would be. So for consumer protection, for public protection, and to address it, I think the middle ground that I think was unanimous with the Regulation Subcommittee was to adopt something like this, just instead of 1 year, 4 years, to be 2 years, 4 years, or something similar to that.
Ira.
I just want to voice my support for longer than 1 year. 2 years seems okay. And one reason is that, well, two reasons. One is that the average consumer of the paraprofessional services compared to lawyer services probably less sophisticated, if that's the right word. And this is important for the should have known part of the 1 year or 2 year. And the other thing is that 1 year is really pretty unfair. I think it's the shortest of the common statute of limitations there is, except for physical injury, as I recall.
Carolyn?
Well, I guess I agree with what Steve is saying. I understand what Ira is saying, and they're both right. But again, we're getting into the can of worms. Do you want this to raise a lot of ire with people? Would you like to generate a lot of letters that will, really not be supportive of the program? This is a hot button issue. The discovery rule works really well. There are plenty of times and cases that someone has said an attorney hid the ball. So when an attorney hides the ball and you can't discover that fraud, the attorney's smarter. The client, unless the client's an attorney, but that's not, neither here nor there. But the discovery rule, which says, if the attorney is hiding the fraud, it could go on up until that 4 years. So that's a long period of time. Frankly, with some of the, if we get into grant deeds and title and Liz Pendens, I think the real estate statute, again, correct me if I'm wrong, is 7 years on those kinds of things. So if you're going to do anything, I would have it match some of those statutes if we're getting into the assistance with grant deed sections. But if it doesn't match what the attorneys have, and the discovery rule is there for protections, and it's very powerful and it works. If you don't match the attorneys, this is a very hot button issue. You're going to get hundreds of letters on this little tiny, it seems like a little tiny point, but it is really important to a lot of people.
Stephen?
To Ira's point, from an insurance underwriting perspective, there's a world of difference between 1 year and 2 years.
Oh, sure.
If you want paraprofessionals to be able to buy malpractice insurance, follow 340.6. If you're more concerned about consumer protection, go elsewhere. Just keep in mind, you're going to make malpractice insurance unaffordable.
Julia?
I thought that they were not going to carry malpractice insurance, but that they were going to have a bond.
They weren't required to.
That's correct, but we want to strongly encourage paraprofessionals to have malpractice insurance.
But there's no exception to the bond. It's either or, correct?
Amos?
Not either or. There are two different things, and best practices would be to have both.
Thank you, Amos.
So I was trying to edit. Thank you to Linda. I was having some problems getting words to respond. What's now on the board is essentially a recommendation that the statute of limitations should mirror that applicable to attorneys, except that the 1 year period for attorneys shall be 2 years for paraprofessionals. So Stephen's informed us that that's the one that typically the 4 year total cap doesn't come into play very often. So it's generally 1 year from either the act or omission or when the client became aware of the act or omission. What is up on the table is changing that to 2 years. Again, the policy issue there is whether that is privileging clients' ability to bring claims over affordability of insurance.
Brady, why not just say governed by Code of Civil Procedures, section 340.6?
That's fine too. It seems like reading the room, there's people on both sides of the issue. So
There are, and I think so,
whichever you guys want to move on.
So Brady,
Yeah.
I think we're going to have to, we'll take a couple more comments, and I will just throw into the mix. There was comment made about maybe needing additional time because of it being less sophisticated of an audience. I'm not sure that that's actually applicable. And it might be for some individuals. I think there are plenty of individuals who are very sophisticated yet do not have the funds to hire counsel. And so I don't know. I just don't know how applicable that is actually going to be. I do think there's a fundamental question about whether we're choosing to treat counsel and paraprofessionals differently for this in a relatively significant way, and that's up to the committee. But I think what we need to have is someone needs to make an actual motion one way or the other. We'll see if we have a second. We'll then take any further discussion and then take a vote. So is there someone who would like to actually make a motion? And if so, tell us what that is. And that will be Stephen Fleischman.
My motion is we revise the resolution to say the statute of limitations for claims against paraprofessionals shall be governed by Code of Civil Procedures, section 340.6.
Right. And so Linda, rather than deleting all of this, I would just move it down so that you don't lose language if you need it. Just move it down and do a new one that says, further resolved, recommends that. And then Stephen, you can slowly say the rest of it.
Sure.